Good morning, everyone. Hope everyone's doing well this morning.
Morning, Judge.
Morning, Judge.
Morning.
Okay, I see we have 7 South on. Who do we have?
Number 40, Mr. Turner.
And Judge, this is a non-negotiated plea. And Judge, this is a non-negotiated plea.
Thank you, Ms. Helen.
Good morning, Mr. Turner.
Good morning, Ms. Helen.
And who do we have presenting for the state this morning?
Your Honor, that would be Ms. Backus. Let me see what her status is. I apologize.
Okay, thank you, Ms. Tortorella. Good morning.
Good morning, Your Honor.
Ms. Helen, I see that balance suspended versus balance probated is at issue, but if he's going to have 6 weeks of anger management and 30 hours of community service, isn't he going to need to be on probation?
Yes, Judge, we wanted to ask if that could be possibly terminated after he completes the conditions. We were just going to see what the court would be willing to be amenable to. But originally, we asked Ms. Backus for time served, balance suspended. I'm currently pre-trying her by email. Should I email her and let her know we're waiting for her?
Ms. Tortorella has let us know that she's coming on.
Yeah, I just sent her the link. I apologize to the court.
Who do we have on from pre-trial this morning?
Good morning, Your Honor. Ms. Jackson.
Good morning, Ms. Jackson. Can we go ahead and get Mr. Turner's history for me, please?
Okay. Can I have just a moment? It seemed like he has a lengthy history. I
Okay,
was just kind of like going through his history in Florida. I apologize to the courts. Just a moment, please.
okay. I'll be back with you. Good morning, Ms. Backus.
Good morning. My apologies for the delay.
Okay, no problem. Good morning, Mr. Turner. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Ms. Backus? You're on mute. You're on mute.
Can you tell me the position we're on, Your Honor?
Oh, I'm sorry. This is position number 40, Keith Turner.
Okay. This is all right. All right, Your Honor. This incident occurred on August 2nd of this year. While working plainclothes, an officer observed an unidentified Black male who was later identified as the defendant gain entry into the Civic Center MARTA station by pushing through the closed fare gate without attempting to pay the fare. Upon approach, the officer displayed his badge, identified himself as a MARTA officer, and advised the defendant of his violation. But the defendant was advised to provide valid identification and any breeze card that he had on him, and he kept yelling, I don't have to show you anything, I'm not going to show you anything. And so the defendant was using profane language and advised officers again that he was not going to show anything. And so the defendant was advised to place his hands behind his back, to be handcuffed, but he resisted. not complying with demands, and refused to place his hands behind his back, and he attempted to walk away from the officer. So after the third time of the officers telling him to place his hands behind his back, then the officer had to grab him by his arms and force him to keep his arms behind his back. The state's offer on this one, Your Honor, was for count 1, 12 months, 30 days to serve, 15 days, balanced probated, 30 hours of community service, 6 weeks anger management. On count 2, it was 12 months, 30 days to serve, credit for time served, 15 days. Count 3, 12 months, 30 days, 15 days to serve, stay away from the incident location, which is the Civic Center MARTA station, and comply with active MARTA suspensions, and he could go non-reporting after the conditions. These are all to run concurrent. I know that the balance probated and balance suspended is at issue. Initially, the non-reporting after conditions was not on the table, and so that is the state's offer at this time.
Okay, Ms. Helen.
Yes, Judge, this is a non-negotiated plea. What we are asking for is time served, balance suspended. He's been incarcerated for the last 15 days. Was arrested on August 2nd, 2022. I believe you read the warrant or the arrest for affidavit. This person immediately walked up on Mr. Turner, immediately physically touched him, and did not announce himself as a plainclothes officer. And so at that point, Mr. Turner immediately told him, please don't touch me. This person immediately came from behind him, did not introduce himself, and did not announce himself as a plainclothes officer. So Judge, Mr. Turner would like to ask this court for time served, balance suspended, with the condition that he not return to that Civic Center MARTA station whatsoever, Judge. And in fact, on that day, he was looking to head to see his daughter. So Judge, on that day, he was arrested and has been incarcerated for the last 15 days from this plainclothes officer. And so Judge, we are asking for time served, balance suspended. We are asking for the 15 days to be enough time for this case.
So you're asking, and maybe I'm missing something, 30 hours of community service and 6 weeks anger management is what I have. Is that what the state's requesting?
Yes, Judge, and we're asking for that to be no conditions. I've spoken to Mr. Turner. He has lost all employment due to incarceration and has no way of completing the 30 hours of community service or the 6 weeks of anger management, which I did inform him he will have to find, he will have to complete it on his own.
Ms. Jackson, do we have the history?
This is his first arrest, Your Honor.
Oh, this is his first arrest?
Your Honor, he's a multi-state offender.
Oh.
He has arrests out of Arizona, California, Virginia, Florida, Indiana, Illinois, Nevada, New York, Ohio. I do see at least 9 cycles. The defendant's last arrest was June the 11th, 2022 for disorderly conduct and theft of a motor vehicle, and that was in Blount County, Georgia. There was no disposition for that one. I do see a felony conviction out of Florida in 2020 for burglary, and I see misdemeanor convictions. There's one in 2022 out of Tennessee for criminal trespassing, one in 2020 out of Florida for obstruction of an officer, an additional one in 2020 out of Florida for petty theft. Nothing in addition, Your Honor.
Okay, well, given that, Ms. Helen, I'm inclined to, I mean, if he doesn't have a job, he can still do community service. So 30 hours doesn't seem to be excessive to me. 6 weeks anger management, he'll have a year to get that completed. So that doesn't seem to be excessive to me. I will, once he completes the terms, make it non-reporting. But he'll have to do the 30 hours in the 6 weeks if he wants to plead guilty to these charges.
Mr. Turner, would you like to accept what the judge just stated? He's accepting the state's recommendation. That's 30 hours of community service. That's 6 anger management classes, and that will be the probation that you're reporting to. Would you like to accept that today?
I would like to speak with you briefly before I Can I go into?
Sure.
Okay, that's fine. We'll put you, I'll go to courtroom 2 and we'll put you into a breakout room, Ms. Helen, with 7 South. So if we could take one of Mr. Finley's cases in courtroom 2, please, and while Ms. Helen speaks with her client.
Good morning, Your Honor.
Good morning.
We're gonna have position number 10, Mr. Glenn Ford.
Okay. And this is a non-negotiated plea, Mr. Finley?
Judge, this is actually gonna be a negotiated plea.
Okay, thank you. Good morning, Mr. Ford. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Okay, thank you, Mr. Ford. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can put your hand down. Thank you. Ms. Tortorella?
Yes, Your Honor. The defendant is being charged with theft by shoplifting. And the offer is 12 months served 30 days, credit for time served 8 days, balance probated, 40 hours of community service, MHET, and stay away from the incident location at Walmart, 844 Cleveland Avenue in East Point, Georgia. And nothing further from the state.
Mr. Finley?
Yes, Judge, that is our understanding of the offer, which we do agree. Judge, we would just ask that once Mr. Ford does complete that community service and does complete that MHET, that the balance of his probation could be terminated. But if not inclined, Judge, then non-reporting would also ask for the probation fees to be waived on his behalf.
Any
And-
objection to non-reporting, Ms. Tortorella?
Yes, Your Honor. The defendant has an open felony case, 20 CP 188911 for financial ID fraud. So the state would object.
Okay, Mr. Ford, it's my understanding that in case 22 CR 005292A, you wish to plead guilty to theft by shoplifting, is that correct?
Correct.
Are you under the influence of any drugs or alcohol at the present time?
Oh, I'm not.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I am.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Ford. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And once you complete the terms, it's going to go to a non-reporting status, okay?
All right, thank you, Your Honor.
All right, good luck to you, sir.
Okay. You good, you good. Next, we have position 11 and position number 12, Mr. Fuller, Reginald Fuller.
And this is non-negotiated, is that correct?
That's correct, Judge.
Good morning, Mr. Fuller. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
I do, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down. Thank you. Ms. Jackson, can I get the history, please, of Mr. Fuller?
Yes, Your Honor. The defendant has 31 cycles. Apologize for the courts. The system is just moving slightly slow.
Okay, you're fine, Ms. Jackson. Thank you.
The defendant's last arrest was July the 30th, 2022 with the city of Atlanta for simple battery. And prior to that, defendant, well, it seemed like he had some additional charges on that arrest. Seemed like criminal trespassing was added to that arrest, Your Honor. Prior to that, the defendant was arrested January the 19th, 2022 in Dunwoody, Georgia for theft by shoplifting and misdemeanor. There was no disposition for that arrest. And prior to that, he was arrested August the 27th, 2021 in Alpharetta, Georgia, for theft by shoplifting, a felony. There's no disposition. Prior to that, the defendant was arrested January the 2nd, 2011 in Dunwoody, Georgia for a felony theft by shoplifting. There's no disposition in the GCIC. And prior to that, the defendant was arrested December the 10th, 2010 with the city of Atlanta for misdemeanor theft by shoplifting. That charge was dismissed. It was dismissed on December the 13th, 2010. And prior to that, he was arrested for a probation violation on November the 11th, 2008 in Cobb County. The underlying charge was not listed for that probation. It just stated it was a felony. And I do see a felony conviction that was out of DeKalb County for felony theft by shoplifting. That was March the 31st, 2009.
Okay, thank you, Ms. Jackson.
Yes, sir.
Ms. Tortorella?
Yes, Your Honor, for position 11, 22 CR 005-076F, the defendant's being charged with battery. The state is offering 12 months served 60 days, credit for time served 18 days, balance probated, 12-week anger management, and no contact with the victim, Jarrell Dixon. The first name is spelled Jerelle. The last name Dixon is traditional spelling. To stay away from 21 Bell Street in Atlanta. For case number position 1222 CR.
Ms. Tortorella, before you move on, since it's non-negotiated, can you give me the facts, please?
Yes, Your Honor. So this the battery is part of a global offer. So for the battery case on January 13th, 2022, the defendant, Reginald Fuller, did wait for the victim, Jarrell Dixon, to come out of the bathroom and struck Mr. Dixon in the face with a closed fist, causing bruising to his eye. The offense occurred at the incident location stated on record, 21 Bell Street. The defendant was eventually arrested, and the events did occur in Fulton County, Georgia. And may I proceed with the second part of the global offer, Your Honor?
Yes, please.
Okay, for 22 CR 005-078F, the defendant is being charged with criminal trespass. The state is offering 12 months served, 60 days, credit for time served, 18 days, balance probated, 50 hours of community service, no contact with, stay away from Lenox Mall at 3393 Peachtree Road Northeast in Atlanta, and 22 CR 005-078F will run concurrent to 22 CR 005-076F. In this case, Your Honor, on July 30th, 2022, the defendant, Reginald Fuller, knowingly and without authority, entered upon Lenox Mall at 3393 Peachtree Road Northeast in Atlanta. After receiving prior to such entry notice that such entry is forbidden. Through investigation, the Atlanta Police Department learned the defendant intended to commit shoplifting. However, the victim did not press charges for the theft by shoplifting. The defendant was arrested, and these events occurred in Fulton County, Georgia. Nothing. Oh, I'm sorry, and I have to go through. So he's he doesn't have any recent convictions as far as battery. He has 31 cycles out of Georgia, 4 cycles out of Ohio. I heard from a pre-trial, he's had several theft by shoplifting arrests. So for that reason, Your Honor, we are offering that the global offer stated on record. Nothing further.
Mr. Finley?
Yes, Judge. So this is a non-negotiated plea with jail time of issue. So the state is asking for 60 days, which after the 2-for-1 would mean that Mr. Fuller would have an additional 12 days. Mr. Fuller served in the Navy for 8 years. He does have serious PTSD stemming from his service. He did have combat experience and was stationed out of Long Beach, California, and made his way over here thereafter. He says this PTSD has played a big factor in some of his issues thereafter. He does want to get to treatment, Judge, and I think treatment is what better suits him rather than a jail cell. So I am asking for 40 days, which after the 2-for-1 would mean Mr. Fuller would just have 2 more days, 2 instead of 12 more, Judge. So once again, I am asking for 40 days. And Judge is asking that once he does complete the anger management and community service, if he could be non-reporting. And lastly, if the probation fees could be waived for Mr. Fuller.
Okay, anything else, Ms. Tortorella?
Yes, Your Honor, we would object to the non-reporting. He has an open felony case, 21 CP 202591 for theft by shoplifting. We're objecting to the non-reporting.
All right. Mr. Fuller, it's my understanding that in case 22 CR 005076F, you wish to plead guilty to battery, and in case 22 CR 005078F, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Thanks, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated. Well, I'll accept the plea. The sentence is going to be 12 months to serve, 40 days, credit for time served, 18 days. The balance is going to be probated, 12 weeks of anger management, 50 hours of community service, and no further contact with Mr. Dixon, and to stay away from the Bell Street address. You're also to stay away from Lenox Mall. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And once you complete the terms of the probation, it'll go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, Mr. Fuller.
Thanks.
Mr. Halvick, position 19 and 20.
Good morning, Mr. Levick. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
I do, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Ms. Tortorella?
I apologize, Your Honor. I was trying to find the unmute. For position 19, 20 CR 003001F, the defendant is being charged with failure to yield right of way to vehicle, possession of open alcohol container, DUI, less safe, and driving while license suspended or revoked. The state's only moving forward with count 3, the DUI less safe.
This meeting is being recorded.
The offer for this case is 12 months served, 120 days, credit for time served, 16 days, balance probated, $1,000 fine, risk reduction, ADET, 240 hours of community service, 1 victim impact panel, and the state will no process the remaining charges. In this case, Your Honor, on November 8th, 2019, at approximately 11:15 p.m., Officer AP Hennessy of the Johns Creek Police Department was patrolling the area of Old Alabama Road and Nesbitt Ferry Road in Johns Creek when he observed a blue Ford Escape with a Georgia tag on a private property parking lot. The officer observed the vehicle backed up in the parking lot at a high rate of speed and then ran over a grass parking median. The officer then observed the vehicle attempted to leave the parking lot and enter the roadway as another vehicle, which was already in the roadway, was passing. The Ford failed to yield by entering into the roadway before the vehicle had a clear path to do so. And based on these observations, the officer decided to conduct a traffic stop. The driver complied with the officer's signal to stop. The officer explained to the driver, identified as Jeff at the time, the observed violations. The officer immediately smelled a strong odor of alcoholic beverage about Jeff's person and asked Jeff if he had consumed alcoholic beverages. Jeff stated he had consumed 1 beer and stated there was a beer in his car. The officer found a glass of cold beer in the center cup holder. Jeff also advised the officer he took medication in the form of Adderall and antidepressants. The officer then conducted field sobriety evaluation, which Mr. Jeff agreed. During the horizontal gaze nystagmus field sobriety, the officer found 5 out of 6 clues. The walk and turn, the officer found 5 out of 8 clues, and Jeff was unable to complete the walk and turn due to high level of intoxication. The officer did not continue with the 1-leg stand evaluation due to his high level of intoxication. Jeff consented to and conducted a modified Romberg field sobriety evaluation, in which the officer also found clues. Jeff was later identified as defendant Jeffrey Labick, and his driver's license was processed through GCIC and found to be suspended since 2018 for DUI drug offenses. The officer placed the defendant under arrest and was read Georgia implied consent notice for suspects age 21 and older. The defendant refused to consent to a state administered chemical test of his blood and urine, and all these events occurred in Fulton County, Georgia. For the second case, Your Honor, 21 CR 000996F, the state will only be moving forward with count 1, DUI less safe. And the offer is 12 months served 90 days, credit for time served 16 days, balance prorated, $1,000 fine, risk reduction, ADT 240 hours of community service, 1 victim impact panel, and the state will no process the remaining charges. 21 CR 000996F is to run consecutive to 20 CR 003001F as in Frank. In this case, Your Honor, on July 18, 2020, at about 12:19 a.m., Officer Rager of the Johns Creek Police Department conducted a traffic stop on a blue Ford Escape for failure to maintain lane at the parking lot of 9850 Nesbitt Ferry Road in Johns Creek. At about 12:39 a.m., Officer Knoll was.
Hold on, courtroom 2, would you mind muting, please?
Oh, I'm so sorry. I thought I was muted. Sorry, Judge.
That's fine. Thank you.
At 12:39 a.m., Officer Knoll of Johns Creek PD was requested to respond due to the driver possibly being under the influence of drugs at the time. Upon Officer Knoll's arrival, he met with Officer Rager, and Officer Rager advised she stopped the defendant due to the traffic violation on Old Alabama Road. She added that the officer seen the defendant earlier in the parking lot of BP at 3700 Old Alabama Road, and the defendant appeared passed out with his pants pulled low. The officer said the defendant then awoke, pulled alongside her to exit onto Old Alabama, looked at her and bobbed his head down as if nodding off, then drove onto Old Alabama Road. Last, the officer said she saw dried blood on his pants, shirt, and hands. Officer Knoll met with defendant and immediately observed he had a pale complexion, and despite being in a relatively dark environment, his pupils were constricted. The officer walked up to the defendant. He could hear him speaking and noted he was doing so in a slurred, thick manner. The officer identified himself to the defendant and explained to him that he was conducting a DUI investigation. The officer noted no odor of alcohol beverage coming from Levac's person. Officer did see the defendant exhibited a circular sway as he stood and also had a slouched posture as if he had difficulty staying upright. Based on the officer's training for drug recognition expert, the officer began to suspect he was under the influence of a narcotic analgesic at the time. And based on this, the officer asked if the defendant would submit to field sobriety. Defendant agreed. On the horizontal gaze nystagmus, the officer observed no clues, but he did note his pupils remained constricted regardless of where he located his light, and they showed little to no response as he brought the light closer. For the walk and turn, the defendant exhibited 6 out of 8 clues. Defendant repeated concerns about his ankles. The officer did not ask him to attempt the one leg stand exercise due to this. An officer did place him under arrest for DUI. He was read the Georgia implied consent from the green card. The officer requested a blood test and the defendant agreed. The officer then transported the defendant to Emory Johns Creek Hospital, where the phlebotomist Jenkins performed the blood draw at about 2:25 a.m. The sample was sealed and turned over to the officer, and all these events occurred in Fulton County, Georgia. Nothing further from the state.
And so what is the, on one position, Ms. Tortorella, I have 12 months to serve 120 days, and on the next position, I have 12 months to serve 90 days.
And that's correct, Your Honor.
But I also have that it's a global offer.
Right, it's supposed to be running consecutive, Your Honor. So that way he has time to complete the risk reduction ADT on both cases. But I'm not sure how Your Honor, if Your Honor would like to run them concurrent. But they're just 2 separate incidents.
I understand that, but generally when you have a global offer, it means you have one offer for both, in this case, both charges, right? So if it's not, either it's going to be 12 months to serve 90 days for both charges or 12 months to serve 120 days, right?
So then I would say it's not a global offer then, as I'm doing it consecutive.
So do you also want him to do 2 risk reductions, 2 ADETs, 240 hours? So you want it to be 480 hours of community service?
I guess for each year, Your Honor, for my understanding is that each DUI offense was a separate transaction. So like I'm going to leave it up to the court if you want to run it consecutive and just do for him to just do the 240 hours, just 1 R&R and ADT, and then the jail time.
Okay, it's not really up to what I want. If you say that this is a negotiated or if it's a plea, it's up to what's been offered. So I'm just trying to figure out what's been offered to the defendant. Good morning, Ms. McCutcheon.
Good morning, Judge Morrow. Ms. Tortorella, what exactly was the plea offer?
The plea offer is as follows. Excuse me. For the first case on position 19, let me make sure I'm in the right position. So I'm offering for the DUI less safe, 12 months serve 120 days, a credit for time serve 106, credit for time serve 16 days, balance probated, $1,000 fine, R&R, ADET, 240 hours of community service, and 1 victim impact panel. We will no pros the remaining. For the second case, 21 CR 000996F. For DUI, it's 12 months served 90 days, credit for time served 16 days, balance probated, $1,000 fine, risk reduction ADT, 240 hours of community service, and 1 victim impact panel. We will no pros the remaining. And then 21 CR 000996F will run consecutive to 20 CR 003001F.
Your Honor, Ms. Tortorella, do you realize the statute mandates the sentence for first DUI, second DUI, et cetera? So you can't really abrogate those statutory mandates. Can Ms. Tortorella and I perhaps go into a breakout room, Your Honor? Because I'm not quite certain it's the state's offer, but I don't think the court has the authority to go to not comply with the statutory mandates as to the number of community service hours, the number of jail time hours, the risk reduction, depending on whether it's a first, second, or third and 10 DUI offense.
Okay, and so thank you, Ms. McCutcheon. So if you all can, we'll put you into a breakout room.
Thank you, Your Honor.
Then once we do that, I will have Ms. Tortorella confer with Mr. Finley. And then Mr. Finley, I guess you'll have to confer with your client. So
Mr. Finley can join the breakout room as well if he'd like, Judge.
okay, all right, very good. So do we have, let's see, do we have
Judge, ready on position 40?
Okay, all right. So can we put
If I could, I'd try to want to see if Mr. Howard, if I can get him on here before so he can assist me in there.
Okay. Is Mr. Howard on with us?
Let me reach out to him really quick.
Okay, all right. So once we get Mr. Howard, we'll put everyone into a breakout room. Until then, we will go back to 7 South with Ms. Helen's case.
Yes, Judge. And the announcement is that this is a negotiated plea. Mr. Turner is agreeing to the judge's recommendation of the 6 anger management and 30 hours of community service and the stay away.
Yes, Your Honor, I apologize. This case was from when our GCIC and NCIC wasn't working. So if I have any of the criminal histories are inaccurate, that would be why we were unable to access last.
Okay, you're fine, Ms. Bacchus.
Thank you.
Let's see. I'm not fine because I can't remember what I said, Ms. Helen. So,
Okay, sure. We start right over.
all right. So what was your understanding? I know we have 30 hours of community service and 6 weeks of anger management. And I said that he would have to do both of those, correct?
Yes, Your Honor.
All right. And that it would be non-reporting after he completed the terms. Is that right?
Correct, Judge.
Okay. And so necessarily it can't be suspended. So it's going to have to be probated, right?
Correct, Judge.
Okay. So 12 months to serve 30 days, credit for time served 15 days, balance probated, 30 hours of community service, 6 weeks anger management, I'll waive fees and non-reporting. Is that your understanding?
Yes, Judge, that is my understanding of the plea. We do accept that plea. We do stipulate to the factual basis, venue, and ID.
Okay. And I take it, Ms. Bacchus, you don't have any objection to that?
No objection, Your Honor.
Okay, very good. Thank you. I'm just going to make sure, I think that I already swore you in, Mr. Turner, but out of abundance of caution, would you please raise your right hand for the court? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, sir. You can put your hand down. Mr. Turner, it's my understanding that in case 22 CR 005173A, you wish to plead guilty to disorderly conduct, willful obstruction of a law enforcement officer, and certain acts on a bus, rail station prohibited. Is that correct?
Your Honor, before I do,
Okay, let me, Mr. Turner, let me also say you have a right to remain silent. Anything that you say can be used against you. I've given you the opportunity to speak with Ms. Helen in a breakout room. If you need to speak with Ms. Helen, I'm happy to let you do that, but you must know that any question that you have for the court, you have a right to remain silent. So, Ms. Helen, do you need to speak with your client?
Yes, Mr. Turner, please don't tell the judge any statements about this case or anything else. It will be used against you. I advise you not to make any other statements. The judge would just like to move through this plea offer, answering or asking you a few questions, okay?
okay.
So my question was, Mr. Turner, it's my understanding that you wish to plead guilty to disorderly conduct, willful obstruction of a law enforcement officer, and certain acts on a bus, rail station prohibited. Is that correct?
Correct.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
you understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury? You don't want a jury trial, do you? Mr. Turner, you do have a right to a jury trial. So if you would like a jury trial, the court is happy to give you that opportunity to have one.
No, my thing is this: my health is very poor, and I'm trying to get out of jail as quickly as I can, and I can't stay in here no longer. So, that's one of the main reasons that I'm willing to take this offer. But I would like to bring up the fact that in the state of Georgia, this is
Mr. Turner.
Yeah. Well, hold on. I can speak on my own behalf. I'm all right.
Judge, if Mr. Turner continues to speak, I'm gonna ask that we can either reset him, because I don't believe he's prepared to take this plea today. So
on my own behalf. As a matter of fact, Your Honor, I would like, it doesn't seem like she's really trying to really, I don't have no criminal history, nothing in the state of Georgia, and this is
okay, Mr. Turner. Yeah. So what I'm going to do today is that I know that you have some consternation, some problems this morning. I'm not going to accept a plea from you today. What I will do is, what I will do is that I'll reset you until the 18th, until Thursday. That'll give you and Ms. Helen another opportunity to speak on this matter. And okay.
Yeah, before you do that, I don't have no criminal history, nothing in the state of Georgia, and this is non-violent. It doesn't involve no drugs or nothing or anything else. And what the state is asking is way too much for a case that doesn't involve no violence, doesn't involve no weapons, doesn't involve no drugs, anything else.
Okay. I understand. I understand what you're saying, Mr. Turner. You don't have to accept. You don't have to accept the offer from the state. Okay. So I understand what you're saying, and we're going to give you the opportunity.
Hey, you know what? And it's not fair. Want to know why? It doesn't have no violence.
Seven South. We're done.
I don't think.
Okay, thank you. Thank you.
15, Mr. Gunn.
I would like a margin hearing. I don't think Miss Helen is properly representing me.
Okay, that's your right, Mr. Turner. So that's why I'm resetting you. Okay.
I request a speedy trial.
Okay.
And I would like
Got number 15.
A preliminary hearing. So they can prove.
And Judge Morrow.
Yes, Mr. Finley.
Yes, Mr. Howard is on the Zoom now. He's board at 10.
Okay. So can we go ahead and put Mr. Howard, Mr. Finley, Ms. Tortorella, and Ms. McCutcheon into a breakout room, please?
Your Honor, good morning. This is South Anna. Before you go to the breakout, I have a situation here that I need you to clear for me. Ms. Shaquilla Hill, position 18. We got a phone call saying that her attorney is not reset her and is not going to be able to be here.
That's correct.
She don't believe us.
Which position is this?
This is position number 18.
To Shaquilla Hill. I don't understand what's going on with my case. I'm being attempted murdered by outside of here by my family. I'm being attempted murder in this jail.
Listen to the judge.
Ms. Hill.
Yes.
Your attorney contacted the clerk yesterday, and he has a conflict letter in for today, so he can't be with us. As such,
I have a bond. I have a bond, and my sister not paying my bond.
Hill, if you're not going to listen to me, if you're not going to, I'm respectful to you, and I'm here what you want to tell me, but you'll have to listen to what I want to tell you also. Okay. So, Ms. Hill, your attorney requested this reset.
Is this the guy that my dad hired?
This is Mr. Samuel Raphael.
That my dad hired, or is he from you guys?
He is not. He's a private attorney, Ms. Hill. So he has requested a reset.
But I don't want that guy to represent me anymore, because when I talk to my dad, his whole conversation is that he is trying to kill me. So if he got anybody representing me, he's trying to kill me too. I just want y'all to do my case. Can y'all just do my case so I can get my time served? I got 3 charges. I got time served. I just want to get out of this jail. I don't like my dad. Every conversation he
Okay,
is
Ms.
on the
Hill,
phone is
Ms.
a tip
Hill,
murder.
Ms.
My
Hill,
sister tip murder me. I got a bond. They won't pay my bond. They won't
okay.
take my
Officer
possessions to pay
Milton,
my
we're
bond.
done. Officer Milton, we're done.
Can you just
We'll be back on the 18th, okay?
Next we got number 15, Mr. Gunn.
All right, so
That's my
15.
position, Judge.
All right, so can we go ahead and put Mr. Finley and Ms. Tortorella, Ms. McCutcheon, and Mr. Howard into a breakout room, please? All right, so then we'll go to 7 South for this Mr. Gunn, is that correct?
Yes, Judge.
Good morning, Mr. Gunn. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down, Mr. Gunn. You've been charged in case 19 CR 008385Y with an HOV lane violation, improper passing in a no passing zone, and fleeing and attempting to elude police officer. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead to these charges, Mr. Gunn? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea and your case will be returned to the division judge and you'll get notification of your next hearing date. Anything further, Ms. Helen?
No, Judge.
All right, good luck to you, Mr. Gunn.
All right, thank you.
You're welcome. All right, let's see, courtroom 2, can we go to a case that's Ms. Helen's case while we await Mr. Lavick?
Then with position 19 and 20.
Say it again.
Are we done with position 19 and 20, Mr. Halbert?
No, we're not done with him, but counsel is in a breakout room. And I would rather move on so that we don't waste any time. So can we go to someone else? That's Ms. Helen's case. If you have any of Ms. Helen's cases in your courtroom.
What number cases does she have?
Oh, I can give it to her, Judge. 13, 14, 17, 21, 22, 25, 27, 28, 31, 35, 36, and 37. 38, and that's it.
Position 31, Monday.
That's a negotiated plea, Your Honor. Oh, Judge, you're muted.
Ms. Bacchus,
Yes, Your Honor.
is position 31 your case?
It is, Your Honor.
Okay, thank you.
For this case, Your Honor.
Just one second.
Go ahead.
Good morning, Mr. Mundy. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Ms. Bacchus?
Yes, Your Honor. For this case, on count 1, the state is offering 12 months, 292 days to serve, credit for time served, 146 days, balance probated, no driving while suspended or driving without license. Count 2, 12 months, 292 days, credit for time served, 146 days, balance probated, 40 hours of community service. That's concurrent with count 1. Count 3 is time served. Count 4 is 12 months, 292 days to serve, credit for time served, 146 days, balance probated, a theft class, and that is also concurrent with count 1.
Yes, Judge, that is our understanding of that plea. We do accept that plea. It is a probated sentence, so we're asking for the probation fees to be waived. And if the state is amenable, once he completes those conditions, if it can be non-reporting.
Any objection to non-reporting?
Your Honor, I don't, and I'm sorry, my Odyssey is moving slow, and ASG McCutcheon is not on for me to. The reason why I have an issue with that is because I believe he's being held on a $16,250 surety bond. He's in jail for a felony, and I like I said, my Odyssey is moving slow, and so I can't pull up the case number. But I would need approval. So for right now, we would object to that until I can get.
Okay, all right. I'm going to have it go non-reporting once he completes the terms.
Okay. Understood, Judge.
Mr. Mundy, it's my understanding that in case 21 CR 004498D, you wish to plead guilty to expired and no license on persons attempting to misrepresent tag, driving on an expired or no license plate or decal, and theft by receiving stolen property. Is that correct?
Yes, but Judge, the TV kind of froze up. I didn't get to hear all the Ms. Helen repeat all the stipulations of the deal.
Okay. So it's 12 months to serve, 292 days, credit for time served, 146 days, which means that you get 2 for 1. And that it's a time served plea, balance probated, 40 hours of community service for count 2, and a theft class for the theft by receiving stolen property. Is that correct, Ms. Helen?
Yes, Judge, and it says no driving without license.
Right, which you shouldn't be doing anyway. Any other questions, Mr. Mundy, regarding that?
No, Your Honor.
Okay, so it's my understanding that you wish to plead guilty to those charges. Is that correct?
Yes, that's correct.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Mundy. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And once you complete the terms of the probation, it'll go to a non-reporting status, okay?
All right, thank you, Your Honor.
All right, you have a good day, sir.
Thank you, Judge.
Who do we have next?
Position 35, Rainey.
That will be a bond hearing today, Judge.
Helen, he said that he never spoke with you, Mr. Rainey.
I sure did. So if Mr. Rainey would like an opportunity to call me on my cell phone, that would be great. Or we can have a breakout session with Mr. Rainey.
You can call in the courtroom. I have put the number in the chat already for you.
I'll go ahead and call.
Okay, so just know that Ms. Helen, if you leave, then we don't have anyone here, anyone else.
Would you like to put him at the end, Judge, or just the very last?
We'll put him on towards the end. We can move on to the next case.
Okay, thank you.
You're welcome. 36, Shellcroft.
And is this your case, Ms. Bacchus?
Yes, Your Honor, it is.
Okay. And this is just going to be an arraignment, Ms. Helen?
Yes, Judge.
All right. Good morning, Mr. Shellcross. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. You've been charged in case 22 CR 002471D with criminal trespass and damage to property. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead to this charge, Mr. Shellcross? Guilty or not guilty?
Not guilty.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
Thank you, Judge.
Okay, are we ready to go back to Mr. Lavick?
Yes, Your Honor. So we're going to treat these as two separate cases. And they would, the state's going to have them run consecutive to each other just because by statute, it's required for him to complete certain things. So, Your Honor, this is his fifth in life. His last arrest was in 2018, and he was convicted on June 4th, 2018 for DUI in this jurisdiction in Fulton State Court. So for the 20 CR case, we're asking for the maximum jail time, a DUI, 12 months served 90 days, credit for time served 16 days, the balance probated, $1,000 fine, risk reduction, ADT, 240 hours of community service as required by statute, and 1 victim impact panel. We will be no processing the remaining charges. For the 21 CR case, this will be his 3rd and 10. 12 months, we're asking for the maximum jail time served 120 days, credit for time served 16 days, balance probated, $1,000 fine, risk reduction, ADET, 240 hours of community service, 1 victim impact panel, and 21 CR will run consecutive to the 20 CR case. And we will be no processing the remaining charges on the 21 CR case. Nothing further from the state.
Okay, are you with me, Mr. Finley?
I'll text him, Judge. He got booted out, Judge. He's just waiting to connect.
Okay. Mr. Finley, do you need to discuss this with your client?
No, I'm okay, Judge. This is kind of similar to what we discussed. He knows we're going to address jail time, so.
Okay, so
actually, you know what? Can I just I'll give him a call really quick, just to briefly.
Okay. Are you with me, Ms. Helen?
Yes, Judge.
Courtroom 2, can we take one of Ms. Helen's cases, please?
Position 39, Thomas.
That's a negotiated plea, Your Honor.
Okay. Good morning, Mr. Thomas. I'm Judge Eric Mora. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Hello, yes, sir.
I'm sorry, is that a yes?
Yes, sir.
Okay, thank you. Can you raise your right hand for me, Mr. Thomas? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, put your hand down. Thank you. Ms. Bacchus?
Yes, Your Honor. On count 1, the state is offering 12 months, 172 days to serve, credit for time served 86 days, balance probated, 30 hours of community service, a theft class, and stay away from the incident location, which is the Kroger located at 2452 Morrisco Way Northeast in Atlanta. And for count 2, 12 months, 172 days, credit for time served 86 days, and balance suspended.
Yes, Your Honor. That is our understanding of the plea. We do accept it and we stipulate to the factual basis, venue, and ID. It's a probated sentence. We are asking for those probation fees to be waived. And if the state is amenable, if it can be non-reporting once he completes that condition.
Your Honor, this case happened on 9/23/2020. He has 5 subsequent cases there to this case. And so the state would object. There's a DUI, there's a criminal trespass, there's a charge that I won't put on the record, a financial transaction fraud in February of this year, and another charge from June of this year that I will not put on the record as well. And so the state would object to the non-reporting.
Okay, I'll waive the fees for Ms. Helen for the entire time.
Understood, Judge.
Mr. Thomas, it's my understanding that in case 21 CR 005521C, you wish to plead guilty to theft by shoplifting and obstruction of a law enforcement officer. Is that correct? You're on mute, courtroom two. Is that correct, sir?
That's correct.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Thomas. I'm going to waive, since you're going to be on probation the entire time, I'm going to waive the fees for you to help you get and stay on your feet, okay?
Okay.
All right, good luck to you, sir.
All right, next we got 28, Mr. McCrary.
This is an arraignment, Ms. Helen.
Yes, Judge. I apologize. What did you ask, Judge?
This is an arraignment.
That's correct, Judge.
Good morning, Mr. McCrary. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Is that a yes?
Yes, sir.
Okay, I'm sorry, I didn't hear you, Mr. McCrary. You have been charged in case 21 CR 007925C with cruelty to animals and dogs at large. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead to these charges, Mr. McCrary? Guilty or not guilty?
Not guilty, sir.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
Thank you, sir.
All right. Who do we have next?
Going back to position 19 and 20, Mr. Howard.
Mr. Finley?
Yes, Judge, we are ready to proceed.
Okay, you can proceed.
Should I go ahead, Judge?
Yes, go ahead.
Okay. All right, Judge. For Mr. Havlich for position 19 and position 20, the jail time is at issue, Judge. For position
Mr. Finley,
I think he froze, Your Honor.
right, I think he's the one that's.
Judge, I'll let him know that his connection is coming through broken, okay?
Okay, thank you.
We'll get through this calendar, Your Honor.
Will we, Ms. Tortorella?
Optimism.
Hey, Judge, he's assessing that connection, may even use his phone.
All right, I think I'm back. Sorry, guys.
Okay, you have to start at the beginning, Mr. Finley.
Okay. I think the last thing I asked was, Ms. Tortorella, can you say again what the jail time is for 19 and 20 that you're asking?
So I'm asking for the maximums by statute for 2nd and 10 for 19 would be 90 days.
Right.
And then for 3rd and 10, position 20 would be 120 days.
Okay. All right. So, yes, Judge. So as you just heard, 19, 90 days, and then number 20, 120 days. So that would mean Mr. Havlich has served 20 days. So after the 2-for-1, position 19, he'd have 25 days. And then, 25 days. And then for position 19, 25 days. And then position 20, it would be an additional 40 days. So I am asking for on each of these for Mr. Havlich to get, it'd be 50 days. So he'd only have an additional 5 days after the 2-for-1. Mr. Havlich is 37 years old. In 2017, he had a stable full-time job, making good money in computer networking. In 2017, he suffered a severe injury, acute compartment syndrome, which was a serious injury to his foot. This led to him being prescribed prescription medication. Thereafter, as we've seen and heard many times happening in society, he went from the progression from pain meds to further drug use, and that kind of led to a spiral in Mr. Havlich's life. As you can see, these cases did happen in 2019 and 2020. Since that time, he went from having a full-time job in computer networking to being homeless and living on the street. He finally started to get on his feet, Judge, in 2022, right before he was detained, because once again, these happened in 19 and 20. So he finally got on his feet. He finally went from sleeping on a sidewalk to sleeping in an apartment. He got a roommate. He got linked up with a temp agency and was holding a stable job. So that is why it is, especially for me, when I spoke to him, heartbreaking to hear how far he came leading up to this last incarceration. And that was really difficult for him, because he felt like, he was finally starting to make some moves and get ahead in his life. And now he's here. So he is in jeopardy, since he's been incarcerated, of losing his job that he worked hard to get, of losing his roommate in his apartment. Leading up to this, he was in the program Atlanta Harm Reduction, which helps with, holding a job, staying off drugs, and kind of just staying on your feet in general. I have met with Mr. Havlich quite a few times, so I do have a rapport with him, and he is clearly someone that has had a hard life, a hard last few years, and has plenty of pain and suffering. So I think his pain and suffering has been enough, and has done a lot more than another few days in jail would. So I am asking for the 50 days on each judge. After the 2-for-1, that would mean he'd only have 5 more days. He could more quickly get out and start right where he left off before this. I would also ask that the probation fees could be waived, Judge, and that once he does complete these conditions, that he could be on non-reporting.
And Your Honor, we just ask that for the defendant to take accountability for his actions. His a DUI history goes all the way back to 2006, Your Honor. This is his 5th in life, and we are concerned for public safety. It seems like he hasn't learned up to this point, Your Honor. So we are asking for the maximums. He does not qualify for DUI court. He has some violent offenses in his history. Otherwise, I would have offered minimums for DUI court. But there needs to be some sort of accountability here, Your Honor.
So I'll let you go. Let me just ask my question real quick. Ms. Tortorella, so you're telling me that between 2006 and the first one of these is 2019, that he had 3 DUIs convictions between those years?
Yes, Your Honor. So, and he had a DUI conviction in February 27, 2006 out of Fulton State Court. December 15, 2008 out of Fulton State Court, DUI conviction. May 10th, 2015 out of Fulton State Court, that was a DUI conviction. On August 9th, 2017, it was a DUI reduced to reckless out of Roswell Municipal Court. And most recently, June 4th, 2018, DUI conviction out of Fulton State Court. This would be the 5th in life, Your Honor.
Okay, Mr. Finley.
Yes, Judge. And I do obviously recognize that. So does he. Obviously, there was one from 2006, one from 2008. He does understand the implications on his driving, and they may not be something in his foreseeable future. But once again, Judge, I think he has served his time. He has had a rough go of it, and just wants to work on himself. And from that time, from 2008 to in the mid 2010s or whatever. He was holding a stable job and kind of had a tough path there, but he is ready, I think, to redeem himself, Judge.
Okay, well, Mr. Finley, based on his history, I am going to accept the state's recommendation on each of the charges. So if that's something that your client wants to accept, we can move forward. If not, then
All right, Mr. Havlich, they are going to. I'm gonna give him a call if I can.
okay, that's fine, Mr. Finley.
And Your Honor, just for the record, Mr. Finley and Mr. Howard and Ms. Tortorella and ourselves did meet in the breakout room to discuss that. So thank you for that, Your Honor.
Okay, you're welcome. I appreciate you trying to work it out for the court. Okay, so let's see, who do we have at the South Annex?
Good morning, Your Honor.
Come on, Mr. Rainey. Where's Mr. Rainey?
We have Ms. Lewis, position 26 here at the South Annex.
And Judge, I believe Mr. Finley has all of the South Annex cases.
Oh, okay, so we can't go to the South Annex. I'm sorry, Mr. Finley's I'm speaking with the client. So can we go back to courtroom 2?
Position 35, Rainey.
Mr. Rainey still needed to speak with me on the phone.
Yes, he did. Go ahead and have a seat. Talbot, you're afternoon. Judge, we can do position 22, Mr. Jackson.
And then, Judge, I think the phones are being used. So I guess I can handle this person or whoever I need to, and we can talk to us.
Is Mr. Jackson your client, Mr. Finley?
Mr. Jackson.
Okay, so apparently Ms. Helen's using the phone for courtroom 2. So Mr.
Finley, is position 22 and 25 your cases?
No, those are both Ms. Helen's.
Can we go back to position 26?
Yeah, that is position 26 is mine.
That's Ms. Lewis is that the South Annex?
Yes.
Okay.
Yes.
All right, very good. Thank you, Ms. Bacchus. Ms. Lewis, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to, can you raise your right hand for me, ma'am? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hands down. Thank you, Ms. Lewis. You've been, let's see, this is a negotiated plea, Mr. Finley.
That's correct, Judge.
Ms. Bacchus.
Yes, Your Honor. For count 1, the state is offering 12 months, 30 days to serve, credit for time served 15 days, balance probated at BHET. If one has not already been done, stay away from the incident location, which is the 5 Points MARTA station, and abide by any active MARTA suspensions. And for count 2, time served and stay away from the incident location.
Mr. Finley.
And that is our understanding of the offer, Judge, of which we do agree. We just ask that once she does complete that the balance of her probation could be terminated or non-reporting, Judge.
Any objection to termination, Ms. Bacchus?
Your Honor, I believe that this defendant has quite a few, but what I'm looking at right now, particularly that is of concern, is this April 2022 K, or it's a 22 CP 206762. There's about 4 to 5, 6, 7, 6 charges within the last 2 years, and 5 within 2022. And so the state would object to the non-reporting because this defendant continually reoffends. And so we are objecting to that.
Okay. On these, we'll let these go non-reporting, Mr. Finley. Ms. Lewis, it's my understanding that in case 22 CR 005168B, you wish to plead guilty to possession and use of drug-related objects and criminal trespass. Is that correct?
Yes,
Are you under the influence of any drugs or alcohol at the present time?
no,
You've been represented by counsel. Are you satisfied with your counsel's representation?
yes,
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
yes,
Has anyone forced or coerced you to plead guilty?
no,
I'll accept the plea as negotiated, Ms. Lewis. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
okay,
All right, good luck to you, ma'am.
thank you.
Thank you.
37,
Which, who?
37,
Okay, so 37, is this Ms. Helen's case, Mr. Finley?
Yes, number 37 is.
Okay, so Ms. Helen's on the phone right now, 5 South, so we'll have to go to someone that's Mr. Finley's case.
Question 33, Your Honor.
33,
Yes, sir.
okay. This is Ms. Palmer.
Yes, sir.
This is going to be a negotiated plea, Mr. Finley.
That's correct, Judge.
Good morning, Ms. Palmer. I'm Judge Eric Murray. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yeah.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Was that a yes?
Yeah.
Okay, thank you, Ms. Palmer. Ms. Bacchus?
Yes, Your Honor, the state's offering 12 months to serve, 12 months, 30 days to serve, credit for time served, 15 days, balance suspended, and stay away from the incident location, which is the Hilton Hotel located at 1031 Virginia Avenue in Hapeville.
Mr. Finley?
And that is our understanding of the offer, Judge, of which we do agree.
Ms. Palmer, it's my understanding that in case 22 CR 005170E, you wish to plead guilty to criminal trespass. Is that correct?
Yeah.
The influence of any drugs or alcohol at the present time?
No,
You've been represented by counsel. Are you satisfied with your counsel's representation?
yeah,
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
how long does it take for a trial, a speedy trial in this state?
Mr. Finley?
I just want to know, what is the speedy trial in this state? The time?
That, ma'am. Do you want to talk further about that? Do you want me to come in and speak?
It doesn't matter, that's okay, yeah,
I can come in and speak with you.
no, that's okay.
So, Ms. Palmer, you understand that you do have a right to a trial by jury, and
Yeah.
that if you plead guilty, you're going to give up your right to a trial by jury. Is that something
Yeah.
that you want to do?
Yeah, that's fine.
Has anybody forced or coerced you to plead guilty?
No, it's all right.
Okay, I'll accept the plea as negotiated, Ms. Palmer. Good luck to you, ma'am.
Yes.
Position 24, Your Honor, Ms. Jones.
And Miss Bacchus, I did just message chat you about this one. I just want to verify how many days you're offering, because it says 50 days and then says time served right next to it. So I just wanted to.
On 24, give me 1 second. I'm pulling it up now. Okay. So let me make sure. Let me look at the calendar to make sure I have the days correct. Okay, so 12 days, so that would be 18. 12 days, so that would be 18 days. What's the date? The 16th. That would be 5 days. Okay, so that's 17 days. Right, so it should be 12 months, 50 days to serve, credit for time served, 17 days.
Okay.
And the count two, also count two and count three, I guess it would be 17, so like 35 days, and credit for time served, 17 days.
Okay. Understood. All right. Thank you.
Does that make sense? I apologize if that was confusing.
No worries.
So you want extra time, Ms. Bacchus? Is that where
Yes.
you're? Okay. All right. So, and this is going to be non-negotiated, Mr. Finley?
Correct, Judge.
Good morning, Ms. Jones. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Ms. Bacchus?
Yes, Your Honor. This incident occurred on July 31st of this year, at the 5 Points MARTA station. The defendant walked up to and intentionally spit on a MARTA employee. Her name was Miss Kendria Cooper. Kendria is spelled Kendria, Cooper, common spelling. The spit landed on Miss Cooper's right arm. And so the MARTA officer approached, and at the time the defendant appeared intoxicated. The officer observed that she was swaying back and forth in a back and forth motion, smelled of alcohol, and was loud and using vulgar and profane language. Your Honor, this defendant has 9 cycles as I have it right now. It looks like there's a reckless conduct and a criminal trespass from March of this year, as well as 3 or 4 days before this, another criminal trespass. And so the state feels as though because of the continual reoffense, and in the same way, and the violent nature of, spitting on someone, but also the March case, the reckless conduct, Your Honor, we feel as though I believe she would have maybe, I'm sorry, I'm bad at math, but I think she would have maybe like 7 or 8 more days to serve, and the state feels as though that is appropriate based on the reoffense. Nothing further from the state.
So she has an outstanding reckless conduct, Ms. Bacchus,
This is correct.
out of Fulton County?
Give me 1 second. I'm sorry, my Odyssey is not.
I'm just trying, if she does, then Mr. Finley, why aren't all these being
Time
taken up
served.
at the same time?
You got time served on that one is what I'm seeing.
Oh, for the March 2022?
For the, yes, it says on Odyssey all the way to the right. Yeah, it says time served.
Yeah, I can't get into Odyssey. I'm sorry.
Okay.
So if that be the case, I think the argument still stands. So even if she got time served, she got the time served on that one. She didn't have to do any more days after she got that. But she then reoffended again, like I said, 4 days before this. And so I still feel as though the state still feels as though the extra days are appropriate.
Okay, and when was, you mentioned a criminal trespass. When is that pending?
I'm sorry, PD Finley, are you able to see that? That is from 7/27/2022.
Yes, ma'am. Yeah, it looks like that was time served as well. So yeah, the one from 7/27/22.
Okay. Mr. Finley?
Yes, Judge. So the state is asking for 50 days, which after the 2-for-1 would mean that Ms. Jones would have 8 additional days. I'm just going to ask for 40 days. So after this, she just have 3 more days. So kind of meeting in the middle. She's going to get more time, but I think 17 days she served, has been a solid amount. So 40 days, and would just mean she would have 3 more days, Judge. And then I would ask that once she completes the anger management, if she can be on a non-reporting judge. And lastly, if her probation fees could be waived.
Well, given her history, I'm going to have her report, Mr. Finley, the entire time. I will waive her fees, and it'll be 40 days to serve, credit for time served 17 days. Okay.
Understood. Thank you, Judge.
And I'm sorry, Your Honor, somebody was banging on my door, so I had to step away for a brief second and send them away. Can you please tell me where all the other conditions was? The 40 days the only thing that was changed from the 50?
Yes, that's the only thing that's changed, but she's going to have to report the entire time on probation.
Okay, thank you so much.
All right, Ms. Jones, it's my understanding that in case 22 CR 005045C, you wish to plead guilty to simple battery, public drunk, and criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and if by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
And I'll accept the plea, Ms. Jones. For the simple battery, it's going to be 12 months to serve, 40 days, credit for time served, 17 days, balance probated, 6 weeks of anger management, no further contact with Kendria Cooper, and stay away from the 5 Point Smarter Station. For count 2, it's going to be 12 months to serve. This was a time served request, I believe, Ms. Bacchus, 12 months to serve, 12 months to serve, 34 days, credit for time served, 17 days. Balance probated with no drugs, alcohol, or weapons, and the criminal trespass, 12 months to serve, 34 days, credit for time served, 17 days, balance probated, and stay away from the 5 Point Smarter Station. I'm going to waive the probation fees for you while you're on probation, Ms. Jones, but you're going to have to be on probation for the entire 12 months. Good luck to you, ma'am.
Thank you, Your Honor.
You're welcome.
Judge, we're ready for position 22, Helen's case.
Okay. Is Miss Helen with us?
Yes, she is.
Yes, Judge.
Okay. And this is Mr. Jackson.
Yes, Mr. Jackson, position 22.
Thank you. This is non-negotiated. Miss Helen.
Yes, Judge.
Good morning, Mr. Jackson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, please? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, sir. Ms. Bacchus?
Yes, Your Honor. On this one, the state offered 12 months, 90 days to serve, credit for time served, 8 days, balance probated, no further contact with the victim, Miss Kiki Dougherty. Stay away from the incident location at 1247 Eubanks Avenue in East Point. This incident occurred on August 2nd. An officer was dispatched to that incident location in reference to a safety check. Upon arrival, the officer spoke to the victim, Kiki Dougherty, who is also the homeowner of the incident location. Ms. Dougherty stated that an unknown Black male attempted to gain entry into the incident location through a rear window that she observed, and that she observed the entire incident on her Ring video camera. So the officer viewed the video footage, which was timestamped, and he observed the Black male. The description he gave was that he had a box-shaped haircut. He was wearing a white t-shirt, black jeans. He had on a crossbody bag. And so he saw him walk onto the front porch, then take his two hands and kind of look inside to see if anyone was there. And then he walked around to the back. I guess he looked straight into the camera before he then walked around to the back porch, tried to use his hands to lift up the window, and then he walked down the steps, obviously without gaining entry into the home. The defendant was seen by this same officer walking in East Point, and when the officer asked him where he was coming from, he said he was coming from work at Spawn Divots, to which the officer informed him that he had just seen him on this camera at the rear of the house on Eubanks Avenue. And he asked why he was at the house, and the defendant stated that he was homeless and that he was looking for somewhere to sleep for the night, and he thought that the house was empty because it had a for sale sign on it. Your Honor, from what I can see, there's 8 cycles here. We've got in 2019, an FTA, a 2020 probation violation, and that would be from, I believe, a 2017, where he had 2 counts, burglary, a criminal damage to property, 3 counts, theft by taking, and he got 9 years probation on the First Offenders Act. That was in 2017. And so he's got that 2020 probation violation, a 2021 driving while suspended, May 2022, June 2022, and a July 2022 probation violation. And so because of the history and all of it is recent, and him already being on that 9 years probation, the state does feel as though the 90 days is appropriate. We understand, we want to be, I myself am, aware of being homeless and whatnot, but that still does not give you the right to break into someone's property or try to attempt to break into someone's property, Your Honor. And so there has to be accountability here. And so the 90 days is appropriate from the state's perspective, nothing further.
Thank you. Ms. Helen?
Yes, Judge, this is a non-negotiated plea. The charge we have here is loitering and prowling. I read the arrest affidavit with Mr. Jackson. He is accepting the consequences of those actions. And that's why I'm asking for a recommendation of 30 days to serve, Judge, with the probation. Mr. Jackson accepts all of those conditions with the probation, but we are asking for a recommendation of 30 days instead of 90 days, Judge. I believe the 90 days is excessive. I do hear what the statements were in the loitering and prowling arrest affidavit, but I spoke to Mr. Jackson and he is willing to understand that will never happen again. And also I've given him resources for housing if he needs those resources, Judge. But we are asking for a recommendation of 30 days to serve.
Your Honor, if I may, just very briefly, again, I do, and I understand what PD Helen is saying. I think my concern is, even though he's charged with loitering and prowling based on the facts and the incident, again, he has that 3 counts of theft by taking and the 2 counts of burglary in the first degree in 2017. And so I'm a little, I don't necessarily agree with the fact that, it is just a means of, I guess a place to stay for the night. It could possibly be that, but he also has a history of theft and breaking and entering. And so trying to open someone's window and gain entry into their home. We as well the state has resources as well to get him housing if need be. But again, the accountability based on the history, the state's position stays the same.
And yes, Judge, we do understand the probation he's on. I do believe this is like the first case. I do hear the FTA and the probation violations, but this is the first case that he's been arrested on, Judge. And so what we're asking is that the 30 days recommendation be the time served with the probation for this case. And again, Mr. Jackson is accepting responsibility for his actions. That's why we're requesting the recommendation for 30 days to serve.
So the balance probated is just for the no contact and the stay away. There don't seem to be any conditions that need to be addressed through probation.
Right, Judge, and I don't believe he stole anything or actually broke into anything, and I guess that's why I didn't see those conditions, Judge.
Yeah, there wasn't and that was exactly why we chose not to do a theft class. But also a check-in to keep him on track. I mean, I guess he can continue on the probation, I guess, that he's on. That I'll defer to you, Judge.
Okay. Anything further?
Nothing further from the state.
Just that he's been incarcerated since August the 9th, so there'd be 8 days.
All right. Mr. Jackson, it's my understanding that you wish in case 22 CR 005293G to plead guilty to loitering and prowling. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept your guilty plea, Mr. Jackson. The sentence is going to be 12 months to serve 45 days, credit for time served 8 days, balance suspended, stay away from Kiki Doherty, no further contact with Ms. Doherty, and stay away from 1247 Eubanks Avenue in East Point. Good luck to you, sir.
All right, next we got number 37, Mr. Smith.
Thank you, Judge.
It was
What
balance
was that
suspended.
position?
37.
And that's my case, Your Honor.
Okay. That's just going to be an arraignment. Is that correct?
That's correct, Judge.
Good morning, Mr. Smith. I am Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yeah.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down. Are you with me, Ms. Helen? Okay, there
Yes,
you go.
Judge, just had to answer my phone.
Okay, you're fine. I just wanted to make sure that you're here with me. Mr. Smith, you've been charged in case 20 CR 004762C with terroristic threats. This charge carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead to this charge, Mr. Smith? Guilty or not? Mr. Smith, guilty or not guilty?
Not guilty.
Okay, I'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
Position 25, Mr. Kendrick.
This is a non-negotiated plea also, Ms.
Yes,
Helen.
Judge.
Good morning, Mr. Kendrick. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Ms. Bacchus?
Yes, Your Honor. The state's offer on this case was 12 months to serve, 12 months, 40 days to serve, credit for time served, 8 days, balance probated, a theft class, stay away from the incident location, the Chevron gas station located at 4485 Washington Road. This incident occurred on August 2nd. An officer was dispatched to the Chevron gas station located at that address that I just stated in reference to a loitering call. Upon arrival, the officer was notified by the store clerk that the defendant had been given 2 warnings in the same date. So the officer, I believe, came out. It's a little foggy, but I believe 2 or 3 times. The first time the officer came out, he saw the defendant was outside the gas station, and every time the officer would approach, he would just go away. But the second time the officer returned, he second or third time, he ended up getting in close proximity to the defendant and observed and could smell that the defendant was intoxicated. And when the officer attempted to question him and gather certain information, the defendant was disoriented and his words weren't making sense. The store clerk said that the defendant stole 3 beers and he walked past all the checkpoints without paying. The criminal history, this defendant has 48 cycles. Since 2020, we've got, there's a lot of criminal trespasses I can't even count. But of concern, I guess I'll go with the last 2 years is just, we've got 1, 2, 3, 4, 5, 6. We've got 7 criminal trespasses from 2021. And we've got an FTA. We've got a bunch of criminal trespass convictions from 2012 all the way down to 2019, Your Honor. And so because of the reoffense, we feel as though the time in jail is appropriate. It is 40 days again. He has credit for 8 days. And so I believe that will leave him with an additional 12 days to serve. And the state feels as though that is appropriate given the history and nothing further.
Yes, Judge, this is a non-negotiated plea. For the public drunk and the theft by shopping and the loitering and prowling, we're asking for time served. The theft class, we're not disputing, and the stay away from the Chevron gas station, we're not disputing. We just think the 40 days to 12 additional days is a bit excessive for the public drunk. And the thing that was stolen was a single beer, Judge, but Mr. Kendrick is here to accept consequences for this case, is willing to stay far away from the Chevron gas station, and is willing to complete that theft class, Judge.
All right, anything further, counsel?
Nothing further, Your Honor.
This is a probated sentence. We are asking for the probation fees to be waived. And we'd ask this court's discretion that once he completes that theft class, if it can be non-reporting.
Does he have a place to live, Ms. Helen?
I have his mother's main address as his place that he'll be residing. Also, I have a note from probation. I believe his parents or his mother and family have been trying to contact him. So, yes.
Okay. Mr. Kendrick, it's my understanding that in case 22 CR 005291A, you wish to plead guilty to public drunk, theft by shoplifting, and loitering and prowling. Is that correct? Courtroom 2, you have to unmute. Is that correct, sir?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept your guilty plea, Mr. Kendrick. The sentence is going to be 12 months to serve 20 days, credit for time served 18 days, balance probated, a theft class, stay away from the Chevron gas station located at 4485 Washington Road. I'm going to waive the probation fees for you while you're on probation, and when you complete the theft class, it'll go to a non-reporting status, okay?
Your Honor, just to clarify, that's credit for time served 8 days, not 18.
Right, did I say 8? I meant to say 8, but it's.
Okay, okay, no, just clarifying, thank you.
Right, so, it's 20 days, you're getting credit for 8 days, 2 for 1, 16 days, so you have another 2 days.
Did you understand that, Mr. Kendrick? The judge gave.
I understand.
Okay.
Okay, good luck to you, sir.
Position 35, Brandon.
Okay.
And Judge, I just want to announce, I believe the alleged accuser in this case is on the line. I just would like her to have an opportunity to speak if you allow, Judge.
Okay, tell me the position.
Mr. Rainey, 35.
35, okay.
Mr. Kendrick, you gave him how many days, Judge?
20. With credit for time served 8. And this is going to be an arraignment and a bond hearing. Is that right, Ms.
Yes,
Helen?
Judge.
Good morning, Mr. Rainey. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down. Mr. Rainey, you've been charged in case 21 CR 007874D with simple battery and theft by taking. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead to these charges, Mr. Rainey? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Ms. Jackson, do you have the history on Mr. Rainey for me, please?
Yes, Your Honor. The defendant has 26 cycles. The defendant's last arrest was July the 21st, 2019 for battery family violence, and that was in Fulton County. The defendant does appear to have an open case pending for possession of a firearm by a convicted felon and possession of cocaine with the intent to distribute and possession of marijuana less than an ounce and possession and use of drug-related objects. That case number is 21-CP-203-780. The defendant appeared to have an additional open case pending for simple battery and theft by taking, and that's in Fulton County. That case number is 21-CR-00787-4 and the letter D. The defendant does have a prior felony conviction. It was in 2007 for the violation of the violation of the Georgia Controlled Substance Act. And one in 2005 for fleeing or attempting to elude an officer in possession of a firearm by a convicted felon. Do see misdemeanor convictions. One in 2018 for no license, and one in 1996 for battery family violence. An additional one in 1996 for obstruction of an officer. Nothing in addition, Your Honor.
Thank you. Ms. Bacchus?
Your Honor, in addition to that, and I don't know if pretrial has this, I'm seeing out of Fairburn, a case, it's an open felony case for affixing materials and fleeing and eluding. It looks like it's 22 CP 210460, and it looks like he's out on an $11,000 bond. Is that, can pretrial verify that? Your Honor, this incident occurred on June 3rd, 2022. An officer was dispatched to 186 Margaret Street in reference to an assault. Upon arrival, the victim, Ms. Victoria Jones, stated that she was at the incident location to get her other vehicle from the defendant, as she said the defendant had been keeping the vehicle or not allowing her to recover it. He had been avoiding her and taking the vehicle elsewhere when she attempted to get it back. So Ms. Jones and the defendant were in her other vehicle, and I guess the defendant was sitting in the back seat as Ms. Jones was in the driver's seat. They were arguing. She had the keys to that vehicle that he had been keeping in her hand when the defendant reached over her shoulder, mushed her in the right side of her face with his elbow and snatched the keys from her hand. Ms. Jones told the officer that she did strike him a couple of times before he got out of the vehicle, and then he took off running. The defendant did return while the officers were on the scene and said that Ms. Jones had broken into his house and destroyed his window, messed up his room. He also said that she had dragged him out of the house by his hair and pulled out his dreads, which the officer said that there was no evidence of him being dragged out or his dreads missing. And he said that there was Mr. Rainey had no shirt on. And so there was no visible marks of him being dragged at all. And there were also no sign of the keys that were taken from Ms. Jones. Your Honor, based on this defendant's history, he's got 27 cycles. Primarily, some of them are very remote, but more recently, in the last 10 years, he's got one conviction for driving without a license, not really concerned about that, but the simple battery, family violence in 2012, I see 2 of those, a 2014 fleeing and giving false name, the 2019 battery family violence, and this current DA case where he's already out on a bond. The state has serious concerns. And so we feel as though there's a $2,500 surety or there's no bond in place, but the state is asking for a $2,500 surety on the simple battery and a $500 surety on the theft by taking. No further contact with the victim, one day anger awareness, and no alcohol, drugs, or weapons.
So why is there not a bond already set?
That I'm not aware of, Your Honor. When I checked in Odyssey, there was no bond set on this. I'm not sure.
And I have the offense date as June 3rd, 2021. Is it 2021 or 2022?
I believe it's 2021. Did I say 2022?
Yes.
I apologize. It is 2021.
Okay, all right.
Your Honor, I just want to make the court aware that the defendant does have an outstanding hold out of Fairburn, Georgia, for fleeing and attempting to elude an officer. The date on that warrant was April the 29th, 2022. Nothing in addition.
Okay. Ms. Helen.
Yes, Judge. This is a bond hearing for Mr. Rainey. He's 45 years old. He was working prior to being incarcerated, Judge, on July 6, 2022. He had been working in construction for the last several months. He is a proud father of 5 children, so he's employable. He does have children. He is a lifetime resident of Fulton County, Judge. I do hear his history. But Judge, what we are asking for today is, number one, a signature bond for the simple battery and a theft by taking. Because when I spoke to Mr. Rainey, Miss Jones had actually found her keys. He was in the back of that car while the police helped her find her keys, as well as the vehicle. So there were other different things spoken during this date that we are asking for a signature bond in the amount of $1,000 for the simple battery, $500 for the theft by taking, Judge. He is employable, and we'll talk about the Ayala factors. I do hear the open cases for the reoffending, Judge. But when I spoke to Mr. Rainey, understands the seriousness of these cases. He will be appearing to all court dates and will not be offending or having new open cases. Judge, danger to the witness or intimidating the witness. Miss Jones is here to ask this court if she can have contact with Mr. Rainey. She would like contact with him, no violent contact, Judge. And again, he will appear to all court dates. So Judge, here we were asking for that signature bond of a $1,000 in a simple battery and a $500 for the theft by taking. If you feel that he is ineligible for that signature bond, we are asking for a surety bond of a $1,000 for the simple battery and $500 for the theft by taking.
Your Honor, the state seriously objects to a signature bond. He's been having simple batteries and batteries since 1993. He has been fighting people and using violence for years on end. And he's got that 2019 battery family violence.
I haven't been convicted.
Oh, wait, Mr. Rainey, let me speak for you, okay?
So I understand PD Helen's argument, but he has his history, the nature of the offense, first of all, and the history with that. If this was his first violent offense, I might be inclined to agree with her, but because he has 6 or 7 different violent offenses over the years that he's not learned from, the state feels as though the surety bond is more than appropriate. Nothing further, Your Honor.
Okay. Ms. Jones, if you would like to address the court, I'll need for you to unmute yourself and raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hands down. Thank you, ma'am. What would you like to tell the court?
First of all, ain't none of this true. I hit him first. He didn't hit me.
Okay. Let me just say this, Ms. Jones.
And then, boy, if he's not been around me, boy, in a relationship, he's going to be around me.
Ms. Jones, I understand that you're emotional, but I can't understand you if you're going to yell. okay?
Okay, I'm saying that, first of all, that statement is not true.
Ms.
He did not
Jones,
strike me
Ms.
first. I
Jones,
hit him first.
Ms. Jones, again, you're gonna have to take your level down for me. Okay, you're not doing Mr. Rainey or yourself any favors right now. Okay,
Okay,
so
can you hear me now?
I can hear you, but you're just gonna have to take it down a bit, okay?
I'm already mad.
All right, so take a breath and tell me what you'd like to tell me.
Okay, what I'm saying is that statement is not true. Whatever the police officer done ran on there, that's not true. He did not hit me. I struck him. And I had got my vehicle. He didn't take my vehicle or none of that. I had 2 cars. I couldn't drive 2 cars at one time.
Okay, have you and
He was
Mr.
only trying to stop me from leaving. And we're together. We actually live in a home together now.
All right, and y'all have been together since 2021?
Been together, but way before that, me and him have been together for 6 years.
Okay. And this hasn't happened again?
No, it hasn't.
Okay. All right, anything else you want to tell me, Ms. Jones?
No, that's it. Never, I'm ready for him to come home.
Okay, all right, thank you, ma'am. Ms. Bacchus,
Yes, Your Honor.
anything further?
Your Honor, just the court is aware of the cycles of violence. The only thing that I would say is she did at that time tell the police, she did admit that she hit him at that time. So I would agree with her on that. But she also said that he did mush her in the face with his elbow and take the keys. That was what was said at the time.
No, I did not.
Ms. Jones, we don't do that here, okay? I'm sorry, Ms. Bacchus, go ahead.
It's okay. Nothing further, Your Honor.
All right. Let's see. You want to take it down, Ms. Helen, so you can get it to the court, please? I would see a modification, but I don't understand why he doesn't already have some type of bond set. It's going to be a $2,000 signature. I'm going to release him to the whole first off. So it's going to be a $2,000 signature bond through the jail for the simple battery, $1,000 signature bond through the jail for the theft by taking, which is going to make it a total of a $3,000 signature bond through the jail. No further violent contact with Victoria Jones, and no drugs, alcohol, weapons while out on bond. Okay.
Thank you, Your Honor.
Understood, Judge.
All right. So Ms. Jones, he's gonna be getting out, but he's got a hold, so he's gonna. It's my understanding he's gonna be not released pending that hold. All right.
Yeah, I know.
All right. So you have a good day.
you.
You're welcome. You also, Mr. Rainey.
Thank you, Judge.
Question about
Thank you.
Who do we have next?
Number
There's a
14.
question, Judge, about the segue.
Yes, excuse me, can I have to stay away from her?
No
No.
violent contact, Mr. Rainey.
Okay.
All right.
All right, we're completed in courtroom to judge.
Okay. Thank you all. We appreciate it.
Thank you.
We still have to finish Mr. Pavlich, 19 and 20.
Oh,
Oh, you still gotta go? Okay.
and what are we gonna? What is going on with Have you had the opportunity to speak with him?
I did, Judge, and we're gonna move forward with a guilty plea.
Okay. So, let's see, since it's been a minute since I've had Mr. Havlick in front of me, can you raise your right hand for me, sir? Do you swear affirm the testimony that you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay. We have gone through this matter. Ms. Tortorella, Mr. Finley, do either of you all have anything else that you need to say before I take the plea?
Nothing further from the state, Your Honor.
Yes, Judge, just that I would ask that the probation fees could be waived
Okay.
for the gentleman for a period of time to help him get on his feet. And also, since he is looks like be on probation for 24 months, if he does finish those conditions before that, if he could be on non-reporting.
Given his history, Mr. Finley, I will waive the fees for him, but I'm going to require that he be on probation for the entire time. Okay.
Understood.
Mr. Havlick, it's my understanding that in case 20 CR 003001F, you wish to plead guilty to driving under the influence of alcohol less safe And in the case 21 CR 0000996F, you wish to plead guilty to driving under the influence of drugs, let's say. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Absolutely, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury.
I do, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir.
All right, I'll accept your guilty plea. Sir, in case 20 CR 0030001F, the sentence is going to be 12 months to serve 90 days, credit for time served 16 days, balance probated, $1,000 fine, risk reduction, alcohol drug evaluation and treatment if necessary, 240 hours of community service, and 1 victim impact panel. On case 21 CR 0000996F, the sentence is going to be 12 months to serve 120 days, credit for time served 16 days, balance probated, $1,000 fine, risk reduction, ADET, 240 hours of community service, and 1 victim impact statement. This charge is to run consecutive with the first charge. I am going to waive the fees for you while you're on probation to help you get and stay on your feet, but you're going to have to be on probation for the entire time. Good luck to you, sir.
Thank you, sir. Just to confirm, that leaves me with about 40 days to serve remaining.
Mr. Finley?
Yes, Mr. Havlich. Yeah, so he, I just checked. He does have 20 days credit for time served on each of these. So yes.
Okay, well, that's going to have to go on the sentence sheet, Mr. Finley. So it's credit for time served 20 days and not 16, as I said.
That's
correct. That right? Okay, so we'll make it 20 days. All right. Thank you. Good luck to you, sir.
All right, next we got number 14, Mr. Green.
And after that position, Your Honor, we have position 32, Ms. Palmer.
Okay, 14 came up first, so let me go with 14 in for Sal. Another non-negotiated plea.
That's correct, Judge.
Let's see. Good morning, Mr. Green. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down. Ms. Jackson, do you have Mr. Green's history for me?
Yes, Your Honor. The defendant has 12 cycles. The defendant's last arrest was May the 30th, 2021 in Chatham County, Georgia, for a probation violation. The defendant appeared to be on probation in Chatham County for aggravated stalking. That disposition date was September the 30th, 2021. The term is for 9 years. I do see one failure to appear that was in 2022. Nothing in addition, Your Honor.
Okay. Ms. Tortorella?
Yes, Your Honor. For count 3, for the battery family violence, the state's offer is 12 months, serve 166 days, credit for time served 83 days, balance probated, family violence intervention program, no contact with the victims. Their names are Talasia Buckner. The first name is spelled TalaYsia. The last name is Buckner. Second victim is Jamia Stewart. It's Jamya Stewart, traditional spelling. And the final victim is a juvenile, LB initials, B as in boy. For the defendant to stay away, 3390 Fairburn Road, Southwest, Building J, Apartment 153 in Atlanta, or wherever the victim may be. 40 hours of community service. Your Honor, in this case, on September 3rd, 2018, Officer Searcy of the Atlanta Police Department was dispatched to the incident location. Upon arriving on scene, the officer began speaking with the victims, Talasia Buckner and Jamia Stewart. Miss Buckner also has a child, LB, who's also a victim, according to the officer. Defendant Rashid Raquan Green was not on the scene. Buckner advised that the defendant and Ms. Stewart were in an argument. Ms. Stewart was holding LB while the argument was going on. The officer was advised that the defendant was in an aggressive, hostile mood, taking the rent money, and the incident escalated from there. The officer was advised police had already been dispatched the night before due to a dispute between the parties. Ms. Buckner advised of being hit repeatedly by the defendant, resulting in very obvious open bleeding injuries just below her left brow. During this incident, the officer was advised the defendant not only struck Ms. Stewart, but also struck LB, who Ms. Baby, whom Ms. Stewart was holding. Ms. Stewart did not complain of an injury, and officers did not observe any injury on LB. Ms. Stewart also advised that the defendant said he would kill her and shoot up whatever location she went to in Savannah, Georgia. The parties involved have lived at the residence together since April of 2018. Ms. Buckner was transported by Grady EMS to South Fulton Hospital for her injury, and Ms. Buckner had a complaint of losing sight in her left eye. The officer did have a second Grady EMS unit respond to the scene and evaluate the baby LB. It was decided LB would be transported to Eggleston Hospital. The defendant was eventually arrested, and these events occurred in Fulton County, Georgia. Your Honor, the defendant pled to a subsequent case against the same victim for aggravated stalking out of Chatham County Superior Court in Savannah, Georgia. Court ruled no contact with victim Jemiah Stewart or son Armani Stewart unless contact allowed through Chatham County Superior Court orders regarding custody. Some of the non-relevant convictions, Your Honor, is fleeing and eluding felony, which occurred on July 1st, 2020, which was subsequent to this case, Your Honor. So for that reason, Your Honor, we are concerned. He also has an open case for battery family violence in Chatham County. The arrest date was September 16th, 2020. I spoke to Chatham County Clerk's office. There are different victims. However, he has that subsequent case against the same victim for aggravated stalking. Therefore, we believe that the offer already stated on record is more than reasonable for this defendant. Not only his history with the victim, but what occurred here in this case. Nothing further.
So, Ms. Tortorella, you're not crossing the cruelty to children and the battery substantial physical harm. Is that right?
Let me double check my offer, Your Honor. I'm sorry, I lost my page. Okay. I'll be no crossing the remaining, Your Honor. Yes.
Okay, so he's only pleading to the battery family violence.
Correct.
Okay, thank you. Ms. Helen?
Yes, Judge, this is a non-negotiated plea. Mr. Green is here to accept consequences for these actions from 2018, Judge. We are asking this judge to allow him to use his NOLO to enter a plea for them. He accepts the probation, the 40 hours of community service, has no contact with Ms. Stewart, no contact with Ms. Buckner or her child, and has not been back or will not ever go back to the 3390 Fairburn Road, Southwest Atlanta address, Judge. So we are here before you asking for his NOLO to be used.
I'm not going to allow him to use a NOLO, Ms. Helen.
So, Mr. Green, I'm going to need a moment to speak to you. Can I get a breakout session or a phone number?
Well, why don't we just go ahead and put you into a breakout room with 4 South? Can we put Ms. Helen on 4 South into a breakout room? Ms. Helen, are the South Annex cases, are those your cases?
No, Judge, those are Mr. Finley's cases.
All right, so we're going to go to South Annex while you're in the breakout at 4 South. Who do we have at the South Annex?
Position 32, Ms. Palmer. Good morning, Your Honor.
Good morning again. Officer Milton, 32, Ms. Palmer. Good morning, Ms. Palmer. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Good morning, ma'am. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case, let me see, 32. This is a negotiated plea. Is that right, Mr. Finley?
Yeah, that's correct, Your Honor.
Can you raise your right hand for me, Ms. Palmer?
Yes.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hands down. Thank you, ma'am. Ms. Barkus?
Yes, Your Honor. For count one, the state is offering 12 months, serve 158 days, credit for time served 79 days, balance suspended, and stay away from the incident location, the MARTA station at 235 Peachtree Street Southwest. Count two, time served, count three, time served. Nothing further.
Okay, Mr. Finley?
And that is our understanding of the offer, Judge, of which we do agree.
Ms. Palmer, it's my understanding that in case 22 CR 003423E, you wish to plead guilty to certain acts on a bus rail station prohibited, criminal trespass, and possession and use of drug-related objects. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Palmer. Good luck to you, ma'am.
Next, we have position number 6, Ms. Kane.
This is also a negotiated plea, Mr. Finley.
That's correct, Judge.
Good morning, Ms. Kane. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
No.
Was that a yes? I'm sorry.
Yes.
Yeah, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, Ms. Kane. Ms. Tortorella?
Yes, Your Honor. For the battery family violence, the state's asking 12 months, served 50 days, credit for time served 25 days, balance probated, family violence intervention program, 60 hours of community service, no contact with the victim, Darlene Kane. Same last name as the defendant. First name is Darlene. To stay away from 2190 Verbena Street. That's V as in Victor, E, R as in Robert, B as in boy, E, N as in Nancy, A Street Northwest in Atlanta. And does defense stipulate to the facts, venue, and ID? Since it's negotiated, or is it not?
Yes, no, it is. And sorry.
Are you done, Ms. Tortorella?
Yes, nothing further.
Okay, Mr. Finley?
Yes, Judge, that is our understanding of the offer. We'll just ask that once Ms. Kane does complete the family violence class and the 60 hours community service, that her probation could be non-reporting. Lastly, just asking for the probation fees to be waived for Mr. Kane or for Ms. Kane, Judge.
Any objection to non-reporting, Ms. Tortorella?
No objection.
Okay, Ms. Kane, it's my understanding that in case 19 CR 007791E, you wish to plead guilty to battery family violence. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Kane. I'm going to waive the probation fees for you while you're on probation. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, Ms. Kane.
Thank you. Next, we have add-on position 1, Ms. Kenetta Bishop.
And just the fine is at issue in this case, Mr. Finley?
That's correct, Judge.
Good morning, Ms. Bishop. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes,
Can you raise your right hand for me, ma'am? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes.
You can put your hand down. Thank you, Ms. Bishop. Ms. Tortorella?
I'm sorry, Your Honor, I'm trying to look for that add-on calendar. Okay, I got it. Yes, so it is for theft by shoplifting. It's 12 months, served 32 days, credit for time served 21 days, balance probated, $500 fine. It cannot be suspended per statute, Your Honor. This is the second one, an anti-theft course. And for the battery, 12 months served, 32 days, credit for time served, 21 days, balance probated, 6 weeks anger management, stay away from the Shell's gas station located at 1468 Holcomb Bridge Road in Roswell. No further contact with Murdia Nar Hussein, and that's spelled M as in Mary, E-R-D-Y-A. Last name is N-U-R-H as in house, U-S-S-A-I-N. And it will be concurrent to count 1. As far as the facts of this case, Your Honor,
That's fine, Ms. Tortorella.
Okay.
Mr. Finley's only objecting, I believe, to the $500 fine. Otherwise, it's all
This
negotiable.
meeting is being recorded.
Okay, Mr. Finley?
Yes,
Are you-
Judge.
I'm sorry, Ms. Tortorella, are you complete? Are you done?
yes, Your Honor.
Thank you. Mr. Finley?
Yes, Judge, and as previously stated, only addressing the fine, we do agree to the anti-theft course, the stay away from further contact. Ms. Bishop definitely understands each of those conditions and will do each of those. Just asking for the fine to be eliminated, Judge. I think that $500 would be best off going towards Ms. Bishop and Ms. Bishop's family and supporting herself. I just think it's best served going to her. So I am asking for that fine to be taken off, Judge. And lastly, that once she does complete that anti-theft course, that if her balance, anti-theft course and the anger management, if her probation could be non-reporting, and if the probation fees could be waived, Judge.
And Your Honor, she did plead guilty to theft by shoplifting in 2021 out of Cherokee County. And by law, Your Honor, that fine cannot be suspended or probated since it's her second conviction. It would be.
Okay. Well, I think that I can convert it into community service as opposed to a fine. So I'm willing to convert it to community service, Mr. Finley, 50 hours of community service, if that would be beneficial to her.
Ms. Bishop, I know we discussed this yesterday. Would you rather do the fine or the community service, ma'am?
I would rather do the fine like we discussed.
Okay, all righty. So we'll stick with the fine.
Well, there will be a $500 fine then. Anything further, counsel?
Nothing further, Judge.
All right, Ms. Bishop, it's my understanding that you wish to plead guilty in case 22 CR 004959Y to theft by shoplifting and battery. Is that correct?
Yes, that is correct.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the plea as stated. I am going to waive your probation fees while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, ma'am.
Thank you.
Could we
Attorney
have-
Finley, I'm sorry. When you get a moment, your client wants to talk to you. Ms. Kane. So when you finish, just give us a call back, please.
Okay, will do. All right.
Okay, so are we going back to 4 South?
Yes, sir.
Okay, this Ms. Helen's case?
Yes, Judge, and that's going to be a negotiated plea.
Okay, tell me what position this is again, please.
That's 14, Judge.
14, thank you. Okay. Mr. Green, it's my understanding the case 21 CR 001464E, you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated. I am going to waive the probation fees while you're on probation, but I'm going to require that you be on probation for the entire 12 months. Good luck to you, Mr. Green.
Thank you.
And Ms. Tortorella, if you can get those null process over to Ms. Champion when you get a moment, please.
Yes, Your Honor.
Thank you.
All right, let's get number 13, Mr. Gonzalez.
This is just going to be an arraignment, is that correct?
Right, Judge.
Good morning, Mr. Gonzalez. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Gonzalez. You've been charged in case 22 CR 005141G with simple battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead to this charge, Mr. Gonzalez? Guilty or not guilty?
Excuse me, sir. I was wanting to request if I can talk to my attorney.
Okay, Ms. Helen, do you want to?
Sure, breakout room, Mr. Gonzalez.
All right, the court will be in recess until Ms. Helen comes back.
PD Finley, is position 27 yours or is it PD Helen?
Let me check really fast. You said 27, Ms. Bacchus?
Yes.
I think that is Miss Helen's.
Okay, so we are in recess. I'll see you in a minute. Okay.
And Judge, we're ready on position 13. That'll be a negotiated plea.
Okay.
This meeting is being recorded.
And so it's the 12 months to serve, 25 days, balance suspended. Is that right, Ms. Tortorella?
That's correct, Your Honor.
Okay. Anything further before I take the plea?
No, Judge.
And nothing further from the state, only that if defense stipulates to the facts, venue, and ID of the matter.
I do, Judge.
All right. Mr. Gonzalez, it's my understanding that in case 22 CR 005141G, you wish to plead guilty to simple battery, family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Yeah, I'll accept the plea as negotiated. And is that 12 months to serve, 25 days, credit for time served, 25 days, balance suspended. Is that correct?
Yes, Your Honor.
Okay. Good luck to you, Mr. Gonzalez.
Next, we got number 17, Mr. Hill. Hill.
And this is just an arraignment, Ms. Helen?
Yes, Your Honor.
Good morning, Mr. Hill. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Hill. You've been charged in case 22 CR 005072A with simple battery. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge, and I want to make an announcement. It's not just an arraignment only. This is actually a bond hearing, so I do apologize about that. That's my mistake.
Okay. How do you plead to this charge, Mr. Hill? Guilty or not guilty?
Guilty.
Well, I'll have a moment to speak to Mr. Hill. Can I get a breakout session?
Okay. So if we can put 4 South and Ms. Helen into a breakout room, please. We'll be in recess until Ms. Helen comes back.
She said she needed to talk to me.
Mr. Jordan, are you there?
Like I said, he tried to.
Yes, sir.
Okay, I just wanted to make sure that you knew that they needed a breakout room.
And now he.
Oh, I'm sorry, Judge. Who needed the breakout room?
4 South and Ms. Helen.
Okay, thank you.
Okay, thank you.
Hey, Judge, we're ready on position 14.
This meeting is being recorded.
17, and it is a bond hearing, Judge.
Okay, I think that we were not quite complete with the arraignment.
Okay.
My last question to you, Mr. Hill, is how do you plead to the charge of simple battery, guilty or not guilty?
Not guilty, Mr. Hill.
Not guilty.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. From the state, who is with us? Okay, so I set this bond back on August 1st. Something that I very rarely do. It's a $5,000 cash bond in the matter, given that apparently his criminal history with an aggravated assault allegation against the same alleged victim, is my understanding. Ms. Helen?
Yes, Judge. This is a bond hearing. We are requesting a modification from that $5,000 cash. When I spoke to Mr. Hill, since August, he's not been able to make that bond. And so what we're asking for is a $5,000 modification to a surety bond. Judge, going through the Ayala factors, he's 38 years old. He is a resident of Fulton County for the last several years. Previously was a resident of Cobb County, but has been a resident of Georgia for the last several years. He is a proud father of 4 children who he's a primary caregiver of. He is also a custodian. That is his full-time profession, Judge. So he is employable. He's been doing that for the last several years, Judge. And so what we are asking, according to the Ayala factors, I've spoken to Mr. Hill about the seriousness of this case. He's going to appear to all of his court dates. He is residentially challenged right now, Judge, but I do have a secondary phone number so that he can get a notice of those court dates, maybe not to an address, but at least to him, a notice of those court dates, Judge. We would also, yes, Judge, we're asking for that modification again, Judge. He is a father, he is employable. I do not believe that he will reoffend once he is out. I don't believe he has any other than the open case. And I do hear the open case, it's still open, Judge. So I don't believe other than that one, he will be receiving any new arrest or charges, Judge. So we are asking for that modification from $5,000 cash to $5,000 surety.
Let's see, Ms. Jackson, do you have his history?
Yes, Your Honor. The defendant has 6 cycles. The defendant's last arrest was March the 10th, 2022 with the City of Atlanta Police Department for driving while license suspended or revoked. That charge was dismissed. The defendant does appear to have an open case pending in Fulton County for aggravated assault. That case number is 21-CP-198750. I do see 1 failure to appear. That was in 2017 out of Alabama. Nothing in addition.
Ms. Tortorella?
Yes, Your Honor. We're very concerned about intimidation of witness victim here. Your Honor, and just to point out for the record, the jail screen states it's a $500 cash bond, but as Your Honor stated, it's a $5,000 cash bond. This defendant had a domestic violence arrest out of Alabama on May 10th, 2016 that involved his ex-wife, according to our investigations. His open case, which is actually prior to this case before this court, involved the same victim, where he obtained a $20,000 surety bond. It's still there. He's supposed to have no contact condition with the victim, and he violated this bond order due to the subsequent offense. In this felony case, Ms. Thomas advised the officers that she was grabbed from behind around the neck and that she could not breathe. Ms. Thomas then advised the officers that Mr. Hill pulled her hair, and the officer did observe that part of her hair was actually pulled out. To add, Your Honor, the victim did speak to us. She is very concerned She did state the defendant pushed her to the bed in this case before us, got on top of her and placed his elbow on her neck and tried to choke her. The victim stated that the defendant did apply pressure, but she was still able to breathe and she did not lose consciousness. She stated that the defendant, in another occasion, the victim stated the defendant placed a screwdriver to her neck about 3 weeks before this incident, and stated that, quote, "I should have been killed you," end quote. The victim stated the defendant is also trying to get their kids taken away. Your Honor, talking about children, this case actually does involve children. So after he assaulted the victim here, he left the scene. Then out of nowhere, the lights were cut off. The officer who responded, the power was cut off. The officer who responded to the scene actually observed the kids were sleeping inside. It was 80 degrees inside the home. It was very hot. And the defendant was doing this in an attempt to get Miss Thomas out so that he could come in, because after the incident, the victim did not want to come inside. The officer did find the defendant hiding in the crawl space of the home. So therefore, Your Honor, we do fear that this defendant will continue to come back to the victim. The victim feels the same way, intimidate her, assault her again. And for that reason, Your Honor, we, if the defendant doesn't want to take accountability of his actions today, Your Honor, we are asking for you to please maintain the bond as set, $5,000 cash bond, nothing further.
Anything further, Ms. Helen?
No, Your Honor.
All right, I am, so take it down, Miss Helen. It's going to be a $15,000 surety bond. No further contact with Ashley Thomas. Stay away from the 1555 DeVille Court address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on bond.
And Judge, there are children. We could get third-party visitation or transfer of the
There'll be
children.
third-party transfer of any minor children. All right, good luck to you, Mr. Hill.
Thank you. Can you say what my bond was? Excuse me. What did they say my bond was?
It is a $15,000 surety bond.
So what would that be, like?
10% of 15,000 for you, Mr. Hill?
Ma'am?
Through a bonding company, you'll be 10%. So you'll have to contact the bonding company, see what that full amount is.
Okay.
I got 21, Mr. Horton.
Okay.
That is an arraignment only, Judge.
Okay. Good morning, Mr. Horton. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
I do.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Horton, you've been charged in case 17 CR 024142Y with no headlights, possession of an open alcohol container, failure to have license on person, driving under the influence of alcohol less safe, and driving under the influence of alcohol per se. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Helen?
I do, Judge.
How do you plead to these charges, Mr. Horton? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Good luck to you, sir.
Thank you.
I'm on the third floor now. Be back on in just a second.
Okay.
Thank you, Judge.
We'll be in recess until the jail comes back.
I got number one, Mr. Barber.
Okay. Mr. Finley, this is going to be an arraignment, bond hearing.
That's correct, Judge.
Good morning, Mr. Barber. Can you hear me okay?
Yeah, I can hear you.
I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
No, sir.
You agree to have your case heard by video?
Yeah, go ahead.
Okay, thank you, Mr. Barber. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court to be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Mr. Barber, you've been charged in case 22 CR 004821C with simple battery. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you want formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to this charge, Mr. Barber? Guilty or not guilty?
Not guilty.
Okay, we'll record your not guilty plea and your case will be returned to the division judge. And you'll get notification of your next hearing date. Ms. Tortorella, I've got there's a pending DA transfer. What's the status of that?
Let me read the facts here. We're not moving forward with the transfer at this time.
Okay, Mr. Finley, what's the current bond?
Yes, Judge. The current bond is a $3,000 surety bond.
Ms. Tortorella, what are the facts?
Yes, Your Honor. On July 21st, 2022, Officer Torres and Officer Meade of the Atlanta Police Department were dispatched to 1180 Peachtree Street in Atlanta, the incident location, regarding an injured person. Upon arrival, officers spoke to security officer Mr. Davis, who was a witness of the incident. Mr. Davis stated there was a homeless man who was lying next to a vehicle on the 7th floor of the parking deck. The victim, Mr. Richard Verdon, last name for the record, V-I-R, D as in dog, E, N as in Nancy, also a security officer, made approach and called for EMS since he did not know the man needed medical attention. Once Mr. Verdon approached the man and asked what was going on, the defendant, Arthur Barber, stated that someone was following him. The defendant started hitting the car that did not belong to him with a black plastic bag that contained all his belongings inside. Mr. Verdon told the defendant to stop what he was doing. Mr. Verdon noticed that the defendant was going around the car towards him as if he was going to charge at him. Mr. Verdon walked back to avoid contact. The defendant hit him with his bag, which caused Mr. Verdon to walk back, hit his shoe with one of the pillars in the parking deck, and fall to the ground. Mr. Verdon attempted to break the fall with his left arm, causing injuries that were treated by Grady at the scene. Once the officer spoke to Mr. Verdon at the hospital, he corroborated the story. And according to Grady, Mr. Verdon had a deformity in his arm and that he needed to get checked with x-rays. Mr. Barber's bag contained a pair of jeans, which he took with him once transferred to custody to Grady detention. These events occurred in Fulton County, Georgia. Your Honor, we are concerned as far as public safety. We were able to speak to the victim. He did actually, due to the fall and him trying to break the fall, caused by the defendant hitting him, he suffered a fracture on his arm, and the victim also advised that the bag also contained an umbrella inside. This defendant pled to aggravated assault. He has 26 cycles. He pled to aggravated assault, family violence, strangulation, reduced to disorderly conduct, and battery family violence in Fulton County Superior Court on May 18, 2017. On October 12, 2004, he pled guilty to simple battery, one count. He had another count which merged, and battery family violence, which was actually, that one was dismissed. So he pled to simple battery out of Fulton County Superior Court. He's had a simple battery arrest in 2003, various violations of probations from 2004 all the way up to 2014 in Fulton County. Given the facts of this matter, Your Honor, and what occurred, what the victim sustained, we do have a fear of the risk of public safety, and the risk of him reoffending while out on bond based on his record. He has 26 cycles. The surety bond granted by Your Honor is more than justifiable for this matter. Nothing further.
Thank you. Mr. Finley, I requested that a social worker visit Mr. Barber. Has that been accomplished?
I did not see that it had been, Judge. I did make a note and send an email out again to make sure that has happened. I haven't heard back yet.
Okay, so I'm not gonna, I specifically wanted someone to visit with him, so I am, would entertain a modification if that had been accomplished, because I think that I had concerns at the SEA calendar. So if you want to put Mr. Barber back on a calendar in the future.
I'm on the line. I can speak with Mr. Barber in the breakout room if you would like.
Okay. Mr. Finley?
Yes, Kasha. Yeah, that works.
Okay. All right, so if we can put Madam Social Worker and 3 South into a breakout room.
You said the social worker, Judge?
Yes.
Who's the social worker on the?
It's Kasha.
I think I see it.
Okay. So while we
sorry, let me interrupt you.
No, you didn't. Go ahead, Mr. Finley.
So just so I better understand, so then I can, decide if we should reset this. Was it about regarding with social worker, just about him standing trial, or is?
I think it was more about if he had a place to go.
Okay.
And what his circumstance was. Okay. In that regard.
Understood.
Okay, Ms. Champion. Okay. While we're waiting, why don't we go over the calendar so that we can.
Your Honor, I apologize. Was there an announcement, or have we already done position 27?
No, Ms. Bacchus.
Okay.
I'm trying not to waste time, and so.
Okay, understood.
All right, so.
Understood.
All right, so also Ms. Champion is here with me today. We've had a good amount of time. I hope you all can just get your paperwork into her as quickly as possible after court today, so that you can get that to me so I can get it signed. Okay, whenever you're ready, Ms. Champion.
Okay, position number 1 was arraigned and reset further notice. He's speaking with the social worker at this time. Position number 2, I see that a waiver of appearance and waiver of arraignment. Mr. Phelan, I have not received that. It's going to be reset further notice. I need to receive that waiver, please.
Yes, ma'am, I will.
Position number 3, defendant made bond is reset further notice. Position number 4 is going to be reset to SAP 823. Position number 5, transfer to the DA's office. The order has been signed. Position number 6 was a plea. Position number 7 shows reset going out to grade. I do not have a reset date. What will be the reset date?
Whose client is Mr. Crane? Is that you, Mr. Finley?
Yes, that is mine.
When would you like that reset until?
We put that out 2 weeks. We can.
Okay.
So that's going to be reset 8:30.
Okay.
Position number 8 is reset SAP 830. Position number 9, reset SAP 823. Position number 10 was a plea. Position number 11 was a plea, and 12 was a plea. Position number 13 was a plea. Position number 14 was a plea. Position number 15, reset further notice, jail jury, defendant was arraigned. Position number 16, reset SAP 823. Position number 17 is going to be reset further notice. Bond was modified to a $15,000 good bond. Position number 18 is going to be reset SAP 830 per defendant's attorney. Position number 19 and 20 was pleas. Position number 21, reset further notice, arraigned. Position number 22 was a plea. Position number 23 is MH reset. What's the reset date, please?
For number 23.
You wanna, if it's a competency calendar reset, it'll be at least 5 weeks.
The other competency calendar reset was set to 9/20. Can we put it on that date?
That's fine with me. Position number 24 was a plea. 25 was a plea. 26 was a plea. 27 were holding. 28 was reset further notice of rain. 29 reset SAP 823. 30 reset SAP 830. 31 was a plea. 32 was a plea. 33 was a plea. 34 reset SAP 823. 35 reset further notice with a bond mod of $3,000 SOB to the jail. 36 reset further notice arraigned. 37 reset further notice arraigned. 38 reset SAP competency 920. 39 was a plea. 40 was reset SAP 818. 41 was reset SAP 823. Add on 1 was a plea. Add on 2 is reset SAP 823. Any questions?
Okay, we'll be in recess until the social worker and Mr. Barber return.
And I'm waiting on Mr. Love, position 27.
Yes.
And Your Honor, I sent over no cross orders.
Okay, thank you, Ms. Tortorella. I received those and they've been signed.
Okay, thank you.
This meeting is being recorded.
Yes, do we have a report? You're on mute.
Good afternoon, Your Honor. Right now, I am not recommending a Grady eval for Mr. Barber. He's very aware of what's going on. He just has some questions for his attorney, and he would like to go forward with his case right now.
Okay, do you know if he has a place to reside?
He does not have a place to reside right now. He does have a mom whom we can get in contact with if he is able to get that information. But right now, he's sort of been living on the streets.
Okay.
I mean, house to house, I'm sorry, from place to place, I would say.
Okay, thank you. Mr. Finley?
Yes, Judge. I mean, I was going to ask for a signature bond on his behalf, hoping that we could get him in somewhere to live. He did tell me that he had been homeless for a long time, but leading up to this was living with a friend for a brief period of time. So he did have a roof over his head. But Mr. Barber is just unable to pay any sort of bond. I do understand Ms. ASG's concern safety wise. He does walk with a walker and he's, has a very, very difficult time even walking or moving his extremities in any kind of way. So I am asking for a signature bond, Judge.
The state only has a concern of how are we going to be able to reach, how is the court, how is going to be able to reach the defendant for future court proceedings? If we currently don't have an address, if signature bond is granted by Your Honor.
Mr. Finley, if you can, I'm happy to reconsider the good bond if you can figure out where he's going once he gets out of custody. I'm
So
happy.
maybe if we could we reset this so I can meet with him and try to nail down and.
Yeah, I'm happy to do that. You've got one of two choices. I'm not going to be here next Tuesday. So if you want me to hear it, then it's going to be 2 weeks from today. I'm happy to let you have someone else hear it if you want to bring it back next Tuesday, or even if you can, it's up to you, Mr. Finley.
Yeah. Mr. Barber, would you be able to hold tight for 2 more weeks until so we can be in front of Judge Morrow?
In jail?
Or reset you to 1 week?
In jail? That's like penalizing me again. I mean, what?
All right.
I'll give you my sister's last name and her.
Well, and if that's the case, Mr. Finley, if you can accomplish this by Thursday, I mean,
Yeah.
because I understand his concern.
Completely, Judge. So if we could just reset this till Thursday.
Okay, so we'll reset it for the 18th. And you're happy to tell whoever the judge is that, that I gave the $3,000 good bond. I'm concerned that that right at the present time, there's no housing. And if housing if he gives us a location, and I was considering modifying the good bond to a signature bond through the jail.
Understood. I will relay that.
All right. Good luck to you, Mr. Barber. So I think that we still have position 27.
Number 27, Mr. Love.
Okay, thank you. And do we have the bond on him? Good afternoon, Mr. Love. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
I don't think he heard you, Judge. It's kind of loud.
We're doing this by video, Mr. Love. Do you agree to have your case heard by video?
Yes, sir.
All right. Can you raise your right hand for me?
Yes, sir.
All right, you've been, do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Love. You've been charged in case 22 CR 005047J. Excuse me, with simple battery and simple assault. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead to these charges, Mr. Love? Guilty or not guilty?
I don't know which way to plead because Judge, I'm telling you.
Okay, I think this was on the, hold on, Mr. Love, hold on. Ms. Helen?
So, Mr. Love, when I came down and spoke to you, you wanted a bond hearing.
Yeah, I do want a bond hearing, but I understand that.
Okay, well, Mr. Love, let's just talk. Can I get a breakout room with Mr. Love real quick?
Have you had a social worker, a social worker visit was requested?
For Mr. Love?
Yes, on the bond. I don't know who said it, but, because it's not signed, but it was a $500 good bond on each charge with a social worker visit prior to the SAP calendar.
I didn't have that done prior to this calendar date, but if Miss Amin is still on the line, we can have her.
Oh,
Mr.
Yes.
Love, he's well known to us.
okay, so so do you need to speak with him, or can you tell me what you know about Mr. Love?
Are you asking me or the social worker, Your Honor?
I'm asking Madam Social Worker.
There's a two-fold situation with Mr. Love. Of course, he has a long-standing history. However, it would be competency would lead to, again, a situation where restoration will be a little difficult because of what you want to say, developmental delays, which is sort of different in having competency restored. Trying to see it as light as possible.
Okay, all right. So, and I've gotten the original bond. It was set by me back in August. I did want a social worker to visit regarding this matter. And I think at the present time, Ms. Heller, you tell me what you want to do. I think that he might need a mental health evaluation.
Your Honor, if we need to at least reset it to maybe have a social worker see him in person to see if this is a competency issue and he needs another mental, or not another, but a mental health evaluation. Could we reset it to Thursday if that's possible?
Okay, I mean, it's fine with me if that's what you want to do.
I would, Judge.
Okay, so we'll reset Mr. Love until Thursday.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, I believe that concludes the calendar for the day. Anything further this afternoon?
Yes, Judge, I apologize. I just want to make sure I have correct information for Ms. Champion. On two positions, the date of confinement were inaccurate. Odyssey stated something different. I don't want the jail to hold those people longer to match up with the credit for time served.
Okay, which case is Ms. Helen?
Position 14, the time I have for Mr. Green is 80 days, not 83. So if I put 83 down, they would hold him for those 3 extra days. I have 80 from Odyssey.
And Your Honor, just respectfully, I, as an officer of the court, whatever Ms. Helen is representing, typically when we go to the jailing screen will indicate how many days. So if Counsel Helen is saying it's 80 days and that's reflected in the jail screen, the state would not be opposed to that. I don't know if that was Ms. Tortorello or Ms. Bacchus.
Ms. Tortorello.
Ms. Tortorello.
Okay.
And one more case,
Oh,
39.
let me make sure we have that correct before we move on. So that was for position number 14, Mr. Green, instead of the 166. To
Instead
serve
of
83
83 days time, Your Honor, it would be 80 days of, Attorney Helen is correct, and my apologies to the court.
And that's fine. We're just trying to get it correct. So it's going to be 160 to serve
Correct,
80.
Judge.
Is that
Correct,
right?
Judge. Correct, Judge.
Okay.
The offer is 166, credit for time served 80 days.
Well, the offer was time served, so if we're still going with the time served, then it's 160 and 80 for credit for time served.
I wasn't aware that when I made the offer, but that's fine, Your Honor.
Okay.
I think what the state's basically saying, the state was recommending 166, but credit for whatever time he has served.
Correct.
83
Okay.
times 2 is 166. I thought they were giving a time served. If that's not,
Right.
That is the time. Okay, it's not my case.
yeah, it's time served what was offered. I just want it corrected to 80, which reflects the current days of confinement.
Well, you know, Judge, respectfully, and typically the state doesn't get involved with, the jail will decide whether or not, whatever amount of time. We're just saying whatever time he served, reduced to the time, even if you say reduced to the time he's previously served. We're not getting into the mathematics. We're just saying we're recommending 166 days reduced in credit for whatever time the defendant has currently served. That way the state doesn't get any issue with the mathematics, and the jail will determine whether it's 2 for 1 or whatever their policy is. But we're saying no additional time, credit for the time, and reduced to the time that he has already served in custody.
But that would mean that he'd have to serve more time in custody. And I don't think that was his.
That was my
intent.
offer, Your Honor, and that was my intention of 166 days credit for whatever time he served.
But you put in 83.
Okay, hold on a second. The man took a time served plea. So either we have to get him back, and there's been a miscommunication to him regarding the time served, because I was under the impression, as I believe that Mr. Green was under the impression, that it was a time served plea.
And Ms. Tortorella, you're not asking for an additional 3 days, am I correct?
If it makes things easier, let's just do the whatever 180 credit for time served.
And I think under
160.
Respectfully, I think in this situation, it's confusing, and the state would agree that it appears that the defendant would have thought that it was credit for the time that he's already served and no additional time, unless we had indicated something different at the time of the plea. So I would say credit for the time that he served, which is the 83 days. Is that correct, Ms. Helen? He served 83 days?
80.
I have 80 according to Odyssey.
Well, then credit for the 80 days then.
Okay, so, but to make it time served, we'd have to
160, Judge, yes, 160.
Okay. All
Right, yes, Judge.
Okay, thank you all.
We all should have taken better math classes, I guess. We need a refresher.
Yeah.
My apologies to the court, yes.
No problem. I think that, what is 12:30 almost? We've been here for a good little while today, so I think we're all a bit fatigued. So we have the paperwork right, Ms. Champion?
Yes.
Okay, all right. So we've got Mr. Green settled. What's your other concern, Ms. Helen?
The other case was position 9, Jose Thomas. The recommendation is 172, credit for time served 86. That's a time served deal. When I looked at Mr. Thomas's days of confinement, I have 51 days. I have
What
that
position, Ms. Helen?
39.
39. Okay. And how many days do you have as time served? Ms. Helen?
Judge, I have a credit for time served from the offer, 86 days.
Okay, and how much time has he served?
I have 51 days.
Shows, he's been in custody for 51 days.
Okay, well, we're gonna have to do a better job of what the time is actually served, because I have on the paperwork that he served 86 days. That's a, and in this case, it's different than the last case, I believe, because 51 days is a lot different than 86 days.
And I do have that he was incarcerated on Odyssey for the theft by shoplifting and the obstruction for additional days. I just wanted the paperwork to reflect the current amount so that he can be released and not be expected to do.
No, I understand that, but this is a whole different situation because this is 30 days. That's as opposed to 3 days in the last case.
Correct, Judge.
So I don't understand what the intent.
Judge,
Yes, Mr. Jordan, thank you.
so it looks like Mr. Thomas was arrested in September 29, 2020.
Correct.
He's 35 days on the original arrest.
Correct.
Okay, so
He's
35.
currently in jail on a state sex offender registry for 51 days, and that's how they added up to 86 days. But the jail is only going to count back the 34 days that he served on 9/23/2020. I don't know if they're even going to give him the credit for the 51 days.
And that, Judge, I just, again, that's.
You have to say that in court for them to get credit, right?
And Your Honor, respectfully, Judge, when the state makes the recommendation on the plea, it is the plea for the instant case. It is not taking into consideration whatever holds, felony cases, or other cases the defendant may have. It's the time served on the instant case that is before the court.
Okay.
And I think that's how
The offer that was given, Judge, was 166 days to serve, credit for time served, 83 days. I just want the numbers to read even so that Mr. Jose can get out. If 51 is that number, I will put that down.
You won't tell me. I mean, if I were Mr. Thomas and I had been represented by my counsel, that it was going to be a time served plea, I'd be very upset now that I have to spend more time in jail. But at the same time, it's up to the jail if he gets 2 for 1, or what's counted and what's not counted. At the same time, it's up to the state to decide, that they wanted 172 days, that they thought that would be correct for this case. I mean, so there's someone sending a message. I don't know if this is.
Ms. Tortorella, was this your case?
No, this Miss Backus's case. However, for Green.
Said position 9?
Oh, position 9?
39.
Oh, 39?
Jose Thomas.
All right, so I'm on his, okay, give me 1 second.
So just while she's doing that, going back to Mr. Green, Attorney Helen, he actually served 3 days, was released, and then was rearrested. That's where he got the 80, and that's where we're getting the 83 from.
Understood, but I'm just saying for the jail and the plea form. The jail will release him on the 83 and not have him serve the additional 3 days, because we've had that happen. I just want the plea to reflect time served.
My understanding is that the jail should give, I can't speak for sheriff's office, but they should give credit for all the amount of time that they've served on the case. But again, that's how we look at it. Like we look at how much credit for overall. If they've been released and then rearrested, we want to give them credit for that time.
Okay, as to, for my position, for position 39, Jose Thomas, I was intending for it to be a time served. So how many days are you saying that you see in the system? Pete, did you say 30?
Currently, he has 51 days of confinement. He did 30 some odd days on the first arrest. His current confinement shows 51.
But that's not for this case.
It was for this case. The theft by shoplifting is attached under some other charges, but it's attached under that booking number on Odyssey, if you do see that.
Okay, so does he have the 51 or the 86? Because what I'm saying is whatever days he has for this case, just double it, just times 2 it.
Okay, so Mr. Jordan says that the jail will probably only give him credit for the original 35 days served in 2020.
Okay, if that be the case, we can do the 70 days and 30 credit for time served 35 days.
Okay. And that will suffice for you, Ms. Helen.
Yes. And also for Mr. Jose, what are the numbers there for position?
That's what we're doing, Ms. Helen.
Okay. And then just to make sure I have it updated for Mr. Green.
Well, there's no update for Mr. Green because we'd already disposed of him and that paperwork has been changed and it's time served.
Awesome. That's it. Just
Okay.
position.
All right. Oh, is everyone good?
Yes, Judge. And in the future, Judge, the state will make certain that we will check the jailing screen, the Odyssey jailing, and we'll verify the information that is in Odyssey. But just for the record, Your Honor, when the state makes a recommendation, it is for the jail time for the instant case, as Ms. Tortorello had done previously. But we'll make sure that we make that clear to the court in our recommendation on the plea offer.
Thank you. I appreciate that. It'll cut down on some miscommunication. Thank you.
Thanks, Judge.
All right. Thank you all. We'll see you next time. You'll have a good
Thank
rest
you
of
as
the
always
day.
for your
Thank
patience.
you.
Thank you, Judge. Good
Thank
day.
you.
Thank you, Judge.
Have a good day.
Thank you, Judge.